Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes. The Supreme Court of North Carolina is now sitting for the dispatch of business. God save the state and this honorable court.
Good morning, everybody. On behalf of the Supreme Court, let me thank the folks here in Edenton for your hospitality and also just for the incredible job that y'all do maintaining the historic nature of your community. It really is a tribute to a lot of hard work from a lot of folks. The Supreme Court is directed by our Constitution to meet in Raleigh or in other places that the General Assembly may designate. In 2004, the General Assembly designated that we could meet here in Edenton in this historic courthouse. We're thankful that we have the opportunity and privilege to be here. I know we've got several school groups that had signed up to be here this morning. The John A. Holmes High School, maybe some 11th graders, and Lawrence Academy from, let's see, Lawrence Academy and Bertie County 9th graders. So we're certainly happy to have all of you visiting with us this morning. It's time now for me to call our first case, which is West et al. Versus Coyle Tire and Axle et al. And we will hear from the appellant.
Thank you, Mr. Chief Justice, members of the court. May it please the court, my name is Vernon Sumwalt. I'm from the Mecklenburg County Bar, and along with my co-counsel, Charles Mast, we represent Ms. Shannon Stocks in this claim, in this appeal. And if we may ask to reserve at least 5 minutes of our time for rebuttal, we would like to do so. Now, I've got a list. It's embarrassing to concede this in front of high schoolers and everyone else, but I've been up here 116 times, not to the Supreme Court, but to the appellate courts, and I've got a list of these cases I've been involved in, and I've not figured out in any of these how to start the argument. And I get in my car yesterday after the early service at church where I play drums. I drive up here and I'm thinking, well, this is the first time I've been before the Supreme Court since COVID. It's been 2.5 years. And I've been to the Court of Appeals, but this is my first chance to see everyone since COVID, which is a blessing in and of itself. But it also got me thinking about electronic filing and the courts being shut down in Mecklenburg and the colleagues that we've lost, from COVID. And the fact that the Industrial Commission kind of picked up the ball and ran with it and got electronic hearings and WebEx went real fast. And I thought something was kind of deep. And it's a good question for all of us. And that is, what have we learned about ourselves from this? And don't answer that because y'all are here to ask me questions. But I think whatever the answer is, it comes down to a value. And I think the values that come out will be different for all of us. So that was my takeaway from the 5-hour trip. And I still didn't come up with anything good to say, except I realized that during COVID, I've been kind of blunt, or could be kind of blunt in saying things directly. So I don't mean it in a rude way. I don't mean it in a disrespectful way. And you've heard the arguments in the briefs with everyone about Fields versus Hollowell, but I'm going to say something and it might startle you, but I'm going to say it and then I'm going to explain where I'm coming from. You are looking at the wrong statute. You're looking at the wrong statute. Ms. Stock's case was kicked out because of a motion to dismiss because of lack of standing. When you don't have standing to prosecute a claim, the court does not have subject matter jurisdiction. In this case, we're not dealing with a court, we're dealing with the Industrial Commission. And what do we know about workers' compensation? If you practice in this area, it's all statutory. It's all statutory. It's like a big house of cards. It's all these statutes that fit together in a certain way, and they make sense if you do this a lot. And when someone who reads the Fields decision looks at the reasoning there, the question in Fields started out with asking whether Miss Fields, who was a common law spouse, could qualify as a widow. And that's almost a circular type question, because unless you are validly married, you cannot be a widow. And that's a legit holding. Where Fields went further is it said in all other cases, because if you look at section 97-39, it's not a statute about standing. It's a statute that creates a statutory presumption that relieves a party of presenting evidence. And then it discusses the quality evidence that if you don't enjoy that presumption, here's how it plays out in trial.
I hate
Yes,
to
ma'am.
interrupt you at this point, but you started out by saying we're looking at the wrong statute. So which do you say is the wrong statute and which do you say is the right statute that we should be looking at?
Yes, ma'am. Fields only looked at section 9739. Fields never cites section 9738. And as opposed to telling you what quality evidence to look at in section 9739, section 9738 tells you who may sue. Now, we've got that statute in the appellant's brief. It's in the appendix on page 8. And here's the thing. Fields says a factual dependent who is not related by family, marriage, bloodline. At least this is the argument that we're hearing from the parties to my left over here. They're saying if you're not related by family, you can't take under the Workers' Compensation Act. Fields decided that under section 9739. What does 9738 say? It says, here's who takes for death benefits. It says death benefits, burial expenses to the person or persons entitled thereto as follows. Number one, persons wholly dependent for support upon the earnings of the deceased employee. Keeps on going. It goes to, if there's no person wholly dependent, then any person partially dependent, then it goes to next of kin. I highlighted language right here. I know this is too small for y'all to read, but y'all have it in front of you on your brief. I went through and I circled one word in this statute, section 9738. And you know how many times the legislature used the word person? 15. 15. Now, you've heard the argument that, hey, South Carolina reached a decision that they would enjoy over here. Virginia's reached a decision that they enjoyed over here. But do you know what the South Carolina legislature and the Virginia legislature have not done? They have not defined the word person. Guess what the North Carolina General Assembly has done? It's on page 3 of the appendix in our brief. So if you rewind to page 3, it's at the very bottom. It's section 97-2, subsection 4. The General Assembly says the term person means individual, partnership, association, or corporation. It means individual. There's no adjective that says individual related by blood. There's no adjective that says individual in your family. There's no adjective that says individual that's a part of your family. It is non-discriminatory. And one thing we know, we warned against judicial legislation. I think regardless of what values we bring to the table today, the court can come together and agree that if there is not a word in this statute, you cannot add that word to the statute. That is judicial legislation.
Well, why is it the word any just as important? Yes.
Because it is. Because there's nothing discriminatory in that definition, but any means any. It doesn't mean just your family members. If the legislature wanted to say only family members are entitled to dependence benefits, they could have very easily done that. They created presumptions to protect these close relatives. That's what Section 9739 did. They created these presumptions to protect children, widows. Next of kin aren't dependents, but there are presumptions there that protect this. So I know, we've heard, and again, I don't know how many oral arguments I've had at the Supreme Court or the Court of Appeals, but there hasn't been a single one where we haven't seen from the other side who have done a good job briefing their cases, but they're always crying that the sky is falling. It's not going to fall with these presumptions. It's
So when
not.
you say that we're looking at the wrong statute, are you saying that Section 97-39 is inapplicable at all?
I'm saying even if it is inapplicable, you got a positive statement by the legislature, 9738, that a person has the right to prosecute a dependency issue. And the question before this court is, Shannon Stocks an individual? I think the answer to that is yes. Because if she is, our legislature says person.
Well, how do we reconcile Section 9738, as you would have us to do, with 9739 in terms of a conclusive presumption? And as you say, in terms of all of this being statutory, if you have a presumption, it's presumed to be rebuttable. But if the term conclusively is involved, that means it's not rebuttable at all, and the outcome, therefore, would operate against your client.
Actually, it wouldn't, Your Honor. Ms. Stocks is not a widow. And earlier, only someone who is validly married is a widow, and that was the issue in Fields. We are claiming a factual dependency. The word any that's in there, the word individual, it doesn't discriminate only with people who are in your family. What the presumption does is it protects those family members. It gives them a conclusive presumption to the exclusion of others that they're whole dependents, if they're a minor child and or a widow. None of which we have here, by the way.
Yeah, but if it is a conclusive presumption, doesn't that obviate the ability to have a hearing? Because a hearing would be an effort in futility if there is not an opportunity to rebut a presumption that's conclusive.
Only if you wanted to rebut the widow's entitlement, but there's no widow here.
So that's why you say it doesn't operate at all.
Right.
There's no
The
widow.
enjoyment of that presumption is the person that gets benefits. It's the widow or the child. But they've got to be a widow that's not living apart for justifiable cause, which we have no evidence of for Sharon West here. Or it's got to be a minor child, which the son and daughter over here, they aren't minor. They're adults. There are no dependents over here. So, I hear the save the babies argument. I hear the save the children because, the dependent children are going to suffer. They're not going to suffer. That's why we have these presumptions.
Well, let me ask you this. Under 9739, the only people who could be entitled to a conclusive presumption would be a widow, which is a spouse living with the employee at the time of death, or a child under 18. Correct? So isn't the key phrase in 9739 the beginning of the second sentence that says in all other cases, i.e. whenever there's not a whole dependent?
Yes, ma'am. And that is the language that Fields looked at. But here's where, with all respect, Fields didn't look at it accurately because it justified it through a moral crusade. It didn't justify it by looking at what the legislature said were the other cases and who could prosecute those cases.
Right. Well, we're not looking at it through a moral lens. We're looking at it through a statutory framework. And I understand that the Court of Appeals and the Industrial Commission felt they were bound by
Absolutely.
Fields and that we are not. And so my question is, what do you contend we should do with Fields?
Ooh, I am always reluctant to say toss it, to reverse it, because there's some merit in saying that you can't qualify as a widow unless you are validly married. But I asked earlier what we learned about ourselves, and the question is, what is the court as an institution when it looks at a case that says, you know what, we came out with a decision this way, but we have a statute whose language is that way. what can we learn about ourselves? Can we go back and say, we didn't talk about that statute.
Some always question, what do we learn about ourselves, which might be an interesting subject of discussion, or is it, what do we do now, given the various doctrines that are intended to try to import certainty into the law? I mean, we've got a decision, rightly or wrongly, that was decided a while back, and the General Assembly's had plenty of opportunity to say, oops, you got it wrong, and as you know, they have been known to do that, particularly in comp cases on occasion. They didn't do it here. So to echo Justice Hudson's question, are you urging us to overrule it, or are you not urging us to overrule it? If you are urging us to overrule it, then what are we supposed to do with the fact that the General Assembly has allowed it to stand as it is for decades?
I think you can overrule it, or you may even be able to push it into a corner saying, look, it was only whether Ms. Fields qualified as a widow, and then the court went off on other issues.
Say that again.
Yeah, it only looked at the issue whether, and they can see this in their briefs, whether Ms. Fields qualified as a widow. I'm saying she didn't. I'm saying Ms. Stocks doesn't qualify as a widow. But what I'm saying also is that doesn't prevent people, any individual or any person who is just a simple dependent and not a family relationship from qualifying under Section 9738. You can also limit Fields by saying it didn't look at 9738.
Well, and I guess that was going to be my other question is, obviously I have read the brief that was filed on behalf of your client. Is the that you're making in reliance upon 97-38 in that brief?
9738 is mentioned, yes.
Is the argument that you have made is in effect, we're looking at Fields looked at the wrong statute, that we need to look at the language in 9738-3 that refers to persons and then refers to the definition of persons again, 97-2-4. Is that argument made in your brief?
The is not specifically, but when you look at any other cases, the question is, what does any other cases in Section 9739 mean?
Well, I guess part of the direct, since it's, if we're going to be direct post-COVID, let's be direct post-COVID. We've
Yes.
got a canon of construction that says that if the General Assembly has allowed a determination to stand for some period of time, that's certainly evidence that that decision should be allowed to remain undisturbed. And then you've got, secondly, the rule that says that you're bound by the arguments made in the brief. I mean, what do we, given those two legal principles, where do we go here?
That is fine for Section 9739, but you also have a remedy under Section 9738. And the rule of statutory construction is also when you have two side-by-side remedies, you can enjoy either one. You've also got the rule set by this court that when there's an ambiguity, between these two statutes, you've got to resolve that ambiguity in terms of coverage. So you can't pick a statute over here when the statute over there, you can't pick a statute over here that closes the courthouse doors when the statute over there opens them or is wide enough to open them just by the language in the definitional sections of the act. So, that's the predicament. That's why it's value judgments, and I don't fault anyone for values. You look at Fields and you realize that was the prevailing thing. I know that when Mr. Mass filed this claim, there was census data and stuff, but we may or may not win that. But if we go to hearing, but we never went to hearing. We had the courthouse doors shut on us. That's.
Let me ask you another question about Fields before you get too far away from that. Is it your position then that Fields can still stand for the proposition that someone can't qualify as a widow by claiming to be a common law spouse?
I think you can narrow its holding to that. And the reason is it's almost a 7-year-old case. Lots has changed in 7 years. I can't pull up online on the court's electronic site to figure out exactly what arguments were presented or pull up the parties' briefs like you can now. So I'm not really sure. When I read Fields, we know a couple of things that are really undisputed. One is Ms. Fields thought she was a common law spouse. Two, and it's undisputed, North Carolina doesn't recognize common law marriages. I mean, let's face it.
Right.
So there wasn't a valid marriage. And the holding initially in Fields was she's not a widow. And you know what? That's not an incorrect holding. That's not an incorrect holding. I think where the court went astray a little bit is when they proceeded to say, well, not only is that the case, but we can never do this because you can't award a live-in fiance or live-in girlfriend or boyfriend or whatever. But you know what? The criminal statute, section 14-44, that talks about a man and wife not being able to live together, yada, 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 because it's immoral. And this word is used in the Fields. I can't pronounce it because it's 5 syllables, but it's lasciviousness or however you say it. That's from the criminal statute. You know, and since then, 2003, we had the U.S. Supreme Court that was mentioned in the PDR of Lewis versus Texas. That statute is probably not constitutional because now we have domestic partnerships. I mean, lawyers who appear before this court are in domestic partnerships, things that weren't covered by the morals back then, no doubt, but which, you know, which have been validated by the federal courts now. And I'm not saying I agree with that. That's not, you know, that's not the song I sing. But when we call 12 people from our communities to serve on our juries, we're calling them there because they're different values. And we're calling them there because those different values bring value to our community. And until our legislature says people who aren't married can't qualify as a general dependent, or people who aren't in the same family can't qualify as a dependent, or actually a person, because that definition doesn't discriminate, then the court cannot add language that does discriminate against them.
Well, and speaking of that, and you mentioned the term values, and that leads me to think about the fact that the General Assembly routinely and inherently considers public policy. And public policy has been an issue in all the briefs.
Yeah.
How do we square public policy being reserved to the legislature with what you have said that this court has erroneously done in Fields and what you are concerned may continue forward?
I think you need to extend an invitation to the General Assembly to clarify this, because I think the General Assembly can figure it out.
What do you contend they need to clarify? What is?
Well, it's not for the purpose of the decision today. They don't need to clarify anything because they haven't stated if you're unrelated, you don't get comp benefits. That's very clear. As that definition of persons doesn't discriminate. What I'm saying is, if it bothers anyone, any member of the court from a value-based system, you can invite the legislature. Say, look, if this doesn't match with your values, please help us out.
Well, the curiosity is, as Justice Irvin has raised, if the legislature has chosen not to visit it actively over the course of the last 70 years since Fields, then why would we, and I say this not facetiously and not rhetorically, but why would we invite them to do something that they know that they can invite themselves to do in the dearth of not having said anything about Fields in 70 years?
Well, because Fields didn't look at 9738. There's nothing that Fields impairs about 9738. Fields is a 9739 decision. And look at Fields. I mean, that's the silver bullet here that, I think it was Bram Stoker, the silver bullet kills the vampires. But the silver bullet is you can read Fields and it never mentions 9738. So how do you close the courthouse doors through Fields? Yeah, if you read the plain language of 9738, it opens the doors for persons, for individuals.
Well, I understood you to be arguing in your brief that 9739 also is unambiguous, so that we don't even get to this question of statutory interpretation and using a canon of construction, relying on what the legislature did or did not do, if the in all other cases language is unambiguous.
In all other cases, it is unambiguous, meaning in all the cases except for the presumption, except for the presumed cases, the factual dependency cases. But the issue we've got, at least when I'm looking at this, is 9739 is not a standing statute. It just tells you the quality of evidence that you have to present in court before the commission. It doesn't say these parties have standing to prosecute the claim. 9738 very clearly says, here's who can prosecute the claim. Here's who has standing. So I'm really not sure why, I don't have an answer to this. I don't know why the Supreme Court addressed the standing issue in the other statute, except it looked at the widow issue, saying, okay, well, Ms. Fields isn't validly married, she's not a widow, and then it went, let's close off the door entirely. Because you look at these things, you look at the language of Fields, and it's pretty value-laden. I mentioned the lasciviousness word that I can't pronounce, but it's against public morals. It goes further. It says it could be added that such a claim is conceived in sin and shapen in iniquity. That's the claim we brought
stated
here.
that this is a construction situation, and you don't dispute that the General Assembly in its intestate secession statutes about people who die without wills, can direct the estate of a deceased to anyone that they determine is best. And, they would say to the wife. And under the facts of this case, the decedent did have a wife, correct? So as we look at the statutory construction, when we look at the definition of widow, it says it includes only the decedent's wife living with or dependent for support upon at the time of his death. And then you look at the presumption under 97-39, as Justice Morgan pointed out, that a widow is conclusively presumed to be wholly dependent in support upon the deceased employee. Why shouldn't we take those statutes at their face, express language, that for a person to qualify as a widow, they have to be dependent upon, but you have an individual who is now conclusively presumed to be wholly dependent. So why would that not qualify the widow under these facts?
Because that's not the full definition of widow. A widow is someone living with the decedent or dependent upon him, or living apart, but the dependent is living apart for justifiable cause. And the facts here.
But it does say or dependent upon.
Right.
It doesn't say, it's not an and, it's an or in there. Or
Well, let's make one thing clear. Sharon West is not dependent on anyone. She was not dependent on Keith West. They had lived apart for 5 years. She was not dependent on anyone. She does not qualify as a dependent. She does not meet the statutory definition of widow. And the three takers of the benefits here split it up just like next of kin would split it up. But guess what? She doesn't qualify under the definition of next of kin, which only looks at children and other relatives, not estranged wives for 5 years. So she doesn't have a dependency, because if she did have a dependency, she would take it to the exclusion of Shannon Stocks, because she is a presumed whole dependent. You take to the exclusion of an alleged partial dependent under Section 9738. So if she really was a whole dependent, we wouldn't be here. I mean, we don't have a claim, because she would be the only person withstanding to take benefits.
Well, let me go back to one things that you said about Fields. It is my understanding that the court in Fields said that the claimant there was not a widow, and also did not fit in all other cases as a dependent, because she was illegally cohabitating, and therefore couldn't put on any proof about why she was a dependent. How can we agree with you, if we do, without overruling that?
What I'm saying is Fields creates an ambiguous set of statutes. Section 9739 closes the courthouse doors, but if you look at the plain language of subsection 4 of 97-2 and 9738, the questions are, is Ms. Stocks an individual? Again, the answer is yes. That means she's a person of that statute. That means the legislature has expressly said that the courthouse doors are open for you. Fields never addresses that statutory framework. So when it pulls that card out of that house, guess what happens to the rest of the house of cards? And all of a sudden, we have arguments that Fields, a Section 9739 case, destroys Section 9738, when our legislature has expressly said any individual any person can prosecute a claim as a dependent. to
So
prove
are you
innocence.
arguing that in essence, what the court did in Fields was sort of amend the statute?
It limited the
implicitly?
statute that the legislature did not limit by express language. And that is, again, that's judicial legislation. When you read subsection 4, the definition of person, it says, means any individual. It doesn't say any family member. It doesn't say any related individual. You've got to add that language in there to get to the result that Fields got. And with all due respect to this court, you can't do that. You can't do that. And hindsight's 20/20. I mean, I think Oliver Wendell Holmes said, law is a magic mirror. And I'm going to goof this up completely. Law is a magic mirror, but it not only looks at what the members of this court and their values and their where y'all are at today, it looks at the generations before us. And it's real easy to look back at the 1953 case and say, oh, gosh, where was Section 9738 in this discussion? It's real easy for us to do that.
Counsel, you're well within your rebuttal.
Yes, sir. I will save my last minute for that. Thank you.
From the appellate.
May it please the court, Chief Justice and Associate Justices, my name is Kelly Stevens, and I represent Jessica Westhave, the daughter of Keith West, the employee that was killed in the industrial accident in Tennessee. The well-established law in North Carolina for over 69 years that only those persons who are related to the employee by blood, marriage, adoption, or otherwise defined under the Workers' Compensation Act may make a claim for death benefit should not be changed to allow anyone, regardless of relationship status to the employee, to make a claim, because doing so would be contrary to the intent of the legislature that passed the laws in 1929, would be inconsistent with other provisions in the act, would be inconsistent with other statutory laws in our state, such as the wrongful death statute, would create absurd results in the administration of benefits, and would frustrate the prompt payment of claims to citizens of this state. It also would create benefits for persons under the law who the employee has no legal duty to support. Therefore, we are asking.
Sorry to interrupt you so early on, but but I do have a question about that. You're not contending that your client is a whole dependent under the statute, are you?
No, Your Honor. My client was an adult child over the age of 18, and therefore she would qualify as a next of kin to receive benefits after the death of her father.
And so you're also not contending that there is any whole dependent,
That there's
any
any whole.
whole dependent in this case.
Well, the employee was married at the time, and even though they were separated, if they were separated due to justifiable reasons, if he had been unfaithful and he was incarcerated, those types of facts, there was a widow in this case.
Right, there was a widow, but
Yeah.
not under the law, a whole dependent as defined in the statute. And as I understand it, no one claimed otherwise.
Yes, my client is not alleging to be a dependent.
Okay, so if there's no whole dependent, and I don't believe that there is any claim here that on behalf of the widow claiming to be whole dependent, then you go to the next sentence of 9739, in all other cases. And my question to you is, why doesn't all include the plaintiff here?
Because the statute, if you look at the statute, which the Fields Court did, you have to look at all of the statutes that relate to death benefits as a whole, because the language in all other cases, in my opinion, is ambiguous. It's open to interpretation, and it can't be read in isolation to the other provisions of the Workers' Compensation Act. So the Workers' Compensation Act was passed as a whole, and there's multiple provisions that relate to each other. So for example, provisions regarding death benefits are actually covered in 4 different sections of the act. 9737 through 9740. The act also has a provision that contains definitions in 97-2. And even though the act doesn't define dependent, it does define classes of people that can be dependents. So when the appellant argues that the language in all other cases means that anyone can make a claim, that's inconsistent with language in 97-2 that actually prohibits certain persons from making claims. So in the case of Martin versus Glenwood Park Sanitarium, when there are provisions of legislative acts that are applicable to the same subject, they have to be read together. And if sections are ambiguous, they are subject to judicial construction to determine legislative intent. And under the Martin case, it says definitions contained in an interpretation of the clause are part of the law, and the court cannot ignore the definitions in the act or the related provisions. And so the Fields Court had a right to look at all of the relevant statutes to determine who could make a claim as a dependent under our Workers' Compensation Act. And there's actually 5 statutes that are relevant to that determination. And the first one is the definitions. And if you look at 97-2 subparagraph 11, when it defines compensation under the act, it says compensation is the money payable to an employee or, and I'm going to quote the statute, to his dependents as provided for in this article, and then immediately defines child, grandchild, brother, sister, parent, widow, and widower, and it also defines adoption. So these definitions state who can be a dependent under the act. For example, only an acknowledged child who's born out of wedlock can be included as a dependent in the act. Only a child who was legally adopted prior to the time of injury can be included. Brothers and sisters include step siblings, half siblings, adopted siblings. It says a parent includes an adoptive parent or any person who for more than 3 years stood in the place of a parent, that's in loco parentis. And so the legislature, in all of these definitions, everyone has some sort of family relationship to the employee through either blood, marriage, or adoption, with the exception of a parent who stands in loco parentis. And the legislature made a decision that that person could make a claim to be a dependent, but said they had to be a dependent for at least 3 years. So the death benefits also talk about, if you look at 9737, that's the provision where an employee is receiving workers' compensation benefits and dies from an unrelated cause. And it states how benefits are paid and the priority. And it says it's paid first to whole dependents, then partial dependents, and then next of kin as defined in this article. So it uses the words as defined in the article. 9738 is the situation where an employee actually dies from the work injury and states that benefits again are paid and who pays, how they're paid in a priority and order. And the statute says that benefits are paid to persons entitled, first whole dependents, then partial, then next of kin. 9739 appears to simply be a burden of proof or evidentiary statute, that in the case of a widow or children under the age of 18, they're going to be conclusively presumed to be dependents. But in other cases, and this could apply to if you have a college student that's over the age of 18, a parent, a brother, a sister, those other people that were previously defined in the statute, that's in the all other cases where they have to prove facts of dependency.
What do you make of Mr. Sumwall's argument based on 9738-3?
I'm sorry?
What do you make of what is your comment, if any, on Mr. Sumwall's argument based upon 97-38-3 that talks about the word person?
Well, I don't agree with that interpretation, but if you look at 9739, further in
The
9730.
reason I ask is Mr. Sumwall basically said that 97-39 was essentially an evidentiary presumption kind of statute. You said something fairly similar to that in one of your earlier answers. And it seems to me Mr. Sumwall's argument, if I'm understanding it correctly, if you've got a minute to tell me that he doesn't, that I don't understand it correctly if I don't. He says in effect 9739 is essentially an evidentiary statutes that 9738(3) is the substantive statute that recognizes the claim.
Yeah, I think that's 9738. Is that what he said?
9738(3) is what I think he was referring to.
Well, the benefits are stated in 9738, but I mean, I think we're getting a little bit, I mean, the statute is simply stating the priority of whole dependents, partial, and next of kin, but these people are defined earlier in the statute. And using the word, there's a case, State versus Beck, that talks about where a literal interpretation of the language of a statute will lead to absurd results or contravene the manifest purpose of the legislature as otherwise expressed, the reason and purpose of the law shall control, and the strict letter is going to be disregarded. I mean, if the statute talks about person, well, all of these people are persons. So we can be critical of the drafters of these laws, but if you look at 97-2, and we probably wouldn't be standing here if the language had been a little clearer and they said, you know, the dependents as defined below instead of saying dependents as provided for below. I think we wouldn't even be standing here. But it was, so I think that you have to look at the fact that there would be absurd results created if interpreted the way the appellant is arguing.
All right, and just so I'll follow you, Ms. Stevens, what are the absurd results that you're referring
Well,
to?
I mean, if anyone can make a claim, why would we need the definition in 97-2? And why would our legislature state that if you were in the process of adopting a child, that child cannot make a claim to be a dependent, but a girlfriend can be a dependent?
So is your absurd results argument, in essence, saying you can't make this argument consistently with the remainder of the statute?
Correct.
Okay, so you're not talking about some person looking at the result that would be reached and saying that's unreasonable. You're saying that the absurd result that you're talking about is the creation of what you believe to be an internal inconsistency in the statutory framework?
Correct.
Okay.
Like, just for example, why would the legislature say someone that stood in the place of a parent, maybe they were going to adopt a child and they didn't get that far, and that they have to actually be a dependent for 3 whole years before they're allowed to make a claim, but we're going to let a girlfriend of 3 months be allowed to make a claim? So that just, you can't reconcile the interpretation of the appellant with the overall, with all of the provisions of the statute taken together. And in this case, I do think.
How do you contend that we should regard then section 97-38? The other side says it should be seen as being dispositive here for allowing Ms. Stocks to be able to be heard by way of a hearing. How should we look at 97-38 in your view?
In my view, 97-38 is simply stating the priority of how the claims are paid, but that the people that are allowed to, you still have to fit into a relationship first. So 97-2, there first has to be a relationship to the employee, a class. You have to be in a class of person that's allowed to make a claim. And then 97-38 is simply stating the priority of who is receiving those benefits.
So you would see 97-39 as being dispositive here?
97-39 in conjunction with what the Fields Court talked about is basically stating that in all other cases only is referring to classes of family members identified in the definition.
And speaking of the Fields case, of course, there's some pretty strong language in that case that's pretty moralistic. What should we do about that language? Should we ignore it? Should we look at it that those were the times 70 years ago, and therefore we need to disregard Fields from that standpoint, but uphold it from a statutory perspective? How should we regard that language relative to whether we should observe Fields, whether we should discount Fields, or whether we should even overturn Fields?
Well, Fields does have harsh language, but I kind of view that more as dicta, because the Fields Court discussed at length the various ways that the employee had no legal obligation to support the claimant who was not his wife. She could not maintain an action for divorce, could not bring an action for alimony, could not inherit a year's allowance, and could be compelled to testify against the employee. And then Fields was followed in the case of Wilson versus Utah, where an employee was living with an unrelated woman and supporting 3 children that were unrelated to him. In the Wilson case, And the court said his act of maintaining the children was voluntary and he was under no legal obligation to do so. So had that employee not died and he terminated his relationship with that woman in the state of North Carolina, she couldn't bring a claim for child support against him. So the Fields Court really, I think, analyzed the statute correctly. They did have this harsh language, but that's really not applicable to looking at reconciling all the provisions of the act. And it is really based on the fact that there's no legal relationship or duty to support someone that's not related to you under the law.
Let me ask a follow-up about that, about Fields. The court in Fields says, and I'm quoting here, manifestly a woman living in cohabitation with a man to whom she is not married is not within the purview of the term, quote, in all other cases, end quote. Can you point me to where in the statute the General Assembly said, limited that definition of in all other cases to that?
Well, I would refer that back to 97-2 that says that where it lists the following, these are the following people that can be dependents under the act. But I'm have to leave some time for the other appellees. Thank you.
But you're not contending that the statute specifically says.
No, I think the statute was ambiguous and I think it did need to be interpreted and that the Fields Court had a right to do that. Yes, thank you.
May it please the court, Chief Justice, members of the court. I'm Randy Cloninger. I represent Raymond Tucker West, who's the adult son of Keith Tucker West Jr., the decedent. One of the things that I would like to do outside of the argument I prepared would be to address a couple things that Mr. Sumwalt had said and a question that was raised by Justice Hudson. Justice Hudson, I will address your question first. You had questioned whether there was a whole dependent here. There was a potential whole dependent here. It's the wife he was married to is Sharon Cash West, who is an appellee here. She was living separate and apart, of course, and I guess it could be inferred or argued that since she was separated for so long, she might not have been dependent upon him. However, that is also a matter of proof, and that was not heard because we entered into a stipulated consent order thereafter between the next of kin and the potential widow. We stipulated that she was a widow because we all believed she was a widow. The part of the statute that I think is very important is this justifiable reason. If you're living apart, justifiable reason, or desertion, it goes on to say. So if he deserted her, she is wholly dependent and unfortunately would take over my client. And so that was one of the reasons that we would consider entering into an agreement with her, is because when she gets up on the stand and presents evidence that she was living justifiably apart because he deserted her or because of his actions, then she is still a widow and is the primary taker.
Is it your contention or understanding that, well, obviously it couldn't be your contention that she was wholly dependent?
It would be my contention that she would be presumptively concluded to be wholly dependent if she qualified as widow under the statute by justifiably living separate and apart. In
which case your client's case would have nowhere to go.
Exactly, Your Honor. And so when you're a practitioner, in my point of view, you pick up Fields and you look at it and you say, well, the girlfriend, she's out. The Fields court eliminates her. The wife, she's the taker if she can prove justifiably living apart or that he deserted her. So as a practitioner, I'm telling my clients, of course, you have to be understanding that this person is the primary taker in this case, according to the law that exists right now. So that would give motivation for the next of kin not to have a lengthy court battle with the potential widow, because when they lose, they're out. And so that's pretty clear. And so I think when you keep saying that there's no whole dependent here, potentially there is. And that would be based on the facts. Of course, we stipulated to that based on the information that we did
Another way
have.
to say what you just said is that you were concerned that the widow, defined colloquially rather than under the statute, might be a widow for purposes of the statute, and therefore you settled your claim.
Absolutely.
Okay.
Absolutely. We would have no incentive if we felt the same way that the appellant feels, that she wouldn't qualify as a widow. We did not feel that way. Of course, that's the whole idea about limiting the takers to family members. Of course, family members are going to fight one another, but more readily, family members will fight strangers to the family. And so in this instance, the girlfriend becomes the stranger to the family. This is a stepmother with two of her stepchildren. When you look at the record, you'll see that these children were about 6 or 7 or 8 years old when the decedent was living with the wife. And so, you know, there is some bonding there. And of course, we immediately settled our case because we understood that we were treating each other like family.
If I can follow up on the question of settling, isn't what you're talking about, doesn't it highlight the fact that there's a distinction between who has standing to bring a claim and what proof they can provide as to whether or not they're independent?
There is a distinction, and that distinction is clearly set out in 9739, and that's where I agree with Mr. Sumwalt. I believe that that is an evidentiary statute. And so, if I'm understanding your question.
Right, and so doesn't the statute doesn't, in the definition section, doesn't have a paragraph that defines dependent, the word dependent, right?
It doesn't, Your Honor.
But it does define person.
It does define person, Your Honor, but when you read it in the context, the persons that they're talking about are the persons that are identified in the statute as potential takers. That's my reading of the statute.
Well, let me ask you about one phrase in 97-39, because the second sentence that talks about in all other cases, it goes on to say, no allowance shall be made for any payment made in lieu of board and lodging or services, which seems to me at least to suggest that if the decedent is paying a rent to a landlord, that's the landlord can't be determined to be dependent. And that phrase helped narrow this question of all other cases, but that they contemplated that all other cases could be other dependents, other individuals who are dependent on the decedent.
I understand that, but I think that the case that addresses that is the McMurray case. The McMurray case basically is a fight between a husband and a wife over who should get. And in that case, the decedent was paying rent to his mother. And so that comes out and says, you can't make that claim because that's not a dependency situation. And it mimics what we have here. As the record will reflect, she was living at this house from 2010 on. From 2015 to 2017, she lived there solely with her two children. At that point in time, she asked her landlord, according to the affidavit that they presented on the response to the dismissal, motion to dismiss, that affidavit establishes that they gave permission for him to move in with her. Okay, so at that point, I'm sorry, with Ms. Stocks, with the appellant. She was the one holding the lease on the house. She was the one that lived there with her children for a significant period of time before he moved in with her.
Well, there was not an evidentiary hearing on these issues, was there?
There was not, but what I'm using, Your Honor, is the affidavits and the documents that were filed in response to the motion to dismiss.
So what, I mean, and I was going to ask somebody this question about running out of time. What, this is here on a motion to dismiss. we've had a lot of discussion in the briefs about could Ms. Stocks qualify as a dependent if her claim was to be recognized? Is that question really before us?
I don't think that question is really before us.
So what do we make of all the factual argument that's contained in the briefs about who, among other things, the subject you just discussed with Justice Hudson?
Well, let me back up a little bit and just say this. When I look at a motion to dismiss, and I think when the courts look at a motion to dismiss, they basically take what evidence there is to look at, like affidavits that have been filed in response to the motion to dismiss, pleadings, et cetera, and they make their decision in the light most favorable to the moving party. So in this instance, when I analyzed it, I took her tax returns, I took the fact that she was the leaseholder, I took the fact that he moved in with her, and even if he's paying his rent, and even if he's making contributions, you also have to subtract out the fact that he's paying for his own expenses. And there's some, in my brief, I address that. Larson addresses it, and I'm running out of time. I'd like to let my co-counsel also speak, but I will say one thing. Based on my analysis in the brief, Larson and Larson's observations, it's my contention that what you would do in this case is you would leave fields intact as to limiting the takers to those people that are defined. You would also then actually not have to worry with the moral issues there by basically, and I think that they are dicta, because when Justice Winborn looks at it and says, these are the people who can take, they're the only people that are obligated, and then Shealy spells it out and says, it's clear that these are the only people that can take, then I think it's a condition precedent, as observed in my brief by Larson, that you have to come within one of those definitions before you have the chance to go to the evidentiary statute, which is 9739. And those are the people that are in all other cases. And I'll yield to co-counsel.
May it please the court, Chief Justice and Associate Justices, I'm Luke West, and I represent the appellants Hoyles Tire and Axle and Travelers Indemnity Company. This case is about the General Assembly's intent to prioritize relationship over dependency in its workers' compensation death benefit statutes. The Fields case dealt with 9739. For the first time today, I'm hearing an argument from the other side about 9738, asking the court to look at 97-2 and read the word person, and on the argument that that definition is dispositive. However, the 97-2 also includes definitions of all of these different family members. So either way, there is ambiguity in 9739, as the Fields Court recognized. There is ambiguity created in 9738 by defining specific members of the family who are entitled to establish dependency under the Act. So the practical import from that is that the Fields Court justifiably and properly interpreted Section 9739, and its holding advances the purpose of the Workers' Compensation Act death benefit statutes. That same principle can be applied to 9738 in this instance, since a similar ambiguity is created. Therefore, it is a justifiable endeavor for the court to look to the legislator's intent in passing that statute as a whole.
I think, again, Mr. Sumwalt can speak for himself, but I think his counter-argument to what you just said would be that unlike dependent person is a defined term in the statute and is not subject to limitation by implication, as your argument suggests, what would be, assuming that's his argument, what would be your response?
If you could rephrase that just slightly for me.
I'll try. The difference between the use of person and the reference to dependent is not defined in the statute. Person is. My sense is that Mr. Sumwalt's response to your argument would be that dependent you can construe, person you can't in a limiting way because it's a defined term in the statute. What would be your response to that argument, assuming that that's what he's going to say when he gets up in his minute?
Thank you. If we treat person in that way, it will have the same effect as treating in all other cases in that way by rendering various other portions of defined family members as essentially superfluous or completely moot, which would be an absurd result. That allows the court to inquire into the legislative intent the General Assembly had in passing it. Furthermore, the legislature's silence on this point should be given significant weight. This court has held as recently as 2017 that the long acquiescence in the practical application of a statute is entitled to great weight in arriving at its meaning. If we agree on nothing else today, it's that we don't know what to do with these contrary provisions that seem to conflict with one another. Our courts also hold that when construing a statute determining legislative intent, the court is permitted to infer that the legislature is aware of judicial construction given to the statute. Appellants urge the court to infer that the legislature is aware of the construction given to 9739 by Fields, but also 9738 by its own words. Since this court's decision in Fields nearly 70 years ago, the General Assembly has taken no steps to repudiate the court's holding or construction or application of that holding as to the standing of unrelated persons. Stocks has shown no subsequent legislative action to show a contrary intent by the General Assembly. This is not a case, and no subsequent statutes reflect a contrary intent. This is not a case where there has been overwhelming change to the concept of familial relation, inheritance, administration of estates. Even if cohabitation is more common than it was when the act was passed, our General Assembly still prohibits common law marriage. And that is an important fact, because if they had moved to recognize common law marriage in the interim between now and the field of holdings, the Fields holding, that would show some intent that the legislature seeks to protect similarly situated persons.
Thank you, counsel.
Thank you, Your Honor.
Rebuttal?
Thank you, Justice. All right, quick hits here. All right. What is a presumption? These presumptive classes, what do they do? There's a rule of evidence. I'm going to butcher this, but I think it's Rule 301. They said it just shifts the burden of proof to the other side. What it doesn't do is these statutory definitions don't create an exclusive list of takers. And it's true that the statute doesn't apply define dependent, because that's not what Section 9738 says. Persons wholly dependent, persons partial dependent. It always attaches back to persons. It always attaches back to persons. So that's where we're coming from. I want to talk about motive real quick, because if you look at the timeline, guess who jumped in last in this game? It was the widow, the alleged widow over here. Not real widow, but the wife. Look at that. And also, we can't be bound by a stipulation we weren't a party to. We were never let in the courthouse. That's the issue here. I'm not saying we'll win in the long run. I'll say we just want the chance to be heard in court. Thank you.
Thank you, Mr. Warren. Mr. Clark?
All right. Oh yes. The Supreme Court of North Carolina will be in recess until 11 a.m. God save the state and this honorable court.
One or two.
Folks, the people that just arrived, just another announcement. All right. The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes. The Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Good morning, everyone. We're glad to see everyone with us today. In particular, I'd like to recognize the Lawrence Academy in Bertie County. I think we have 7th graders from there, so welcome. The Constitution of our state says that the Supreme Court is to meet in Raleigh or such other places as the General Assembly may designate. In 2004, in recognition of this historic courthouse and the role that Edenton historically has played in the history of our state, the General Assembly designated that we would be able to hold court in Edenton. So our Supreme Court is grateful to be here. We thank everybody for your presence in our courtroom today. And of course, this is being live streamed across the state and nation around the world, I guess. So good morning. Our next case is State versus Rollinson, and we will hear from the appellant.
Thank you, Mr. Chief Justice. Please the court. My name is Brandon Mays, and I represent Mr. Rollinson. I would like to reserve 10 minutes for rebuttal. Your Honors, this case is about whether the trial court's failure to conduct a colloquy and establish that Mr. Rollinson's waiver was knowing and voluntary was a substantial violation of our waiver statutes. The answer should be yes. It is also about what this court should do about this kind of error. Generally, this court applies per se error and vacates judgments without requiring a defendant to show prejudice. This court should do the same here. Moreover, by doing so, this court can clarify its waiver of a right to jury trial jurisprudence and provide trial courts with a bright line rule on what they must do before consenting to such waivers. I plan to begin my arguments by explaining how the Court of Appeals erred and concluding the trial court here personally addressed Mr. Rollinson and Mr. Rollinson's waiver was knowing and voluntary. I plan to spend the majority of my time explaining what this court should do about that error and why it should apply error per se. Turning first to the trial court's error. Here, the Court of Appeals held that the trial court personally addressed Mr. Rollinson and that his waiver of the right to a jury trial was knowing and voluntary because nothing in the record established that his waiver was unknowing or involuntary. This holding is wrong for 2 reasons. First, the record reflects that the trial court did not, in fact, address Mr. Rollinson personally. And second, its knowing and voluntary analysis flips the burden on its head. Here, the record reflects the trial court did not address Mr. Rollinson personally. In fact, Mr. Rollinson did not request a bench trial at the beginning of the habitual felon phase. It was only after prompting by the prosecutor that the trial court recognized the bifurcated nature of the proceedings and stated that the jury was coming back, or you can waive your right to a jury trial. Importantly, Mr. Rollinson did not respond. After conferring with his counsel, Mr. Rollinson's trial counsel responded. Because the trial court did not address Mr. Rollinson, and because his attorney answered for him, the trial court did not satisfy the first requirement under Section 15A 1201 D1.
Let me get some clarification from you on that. In terms of talking about this word personally that appears in the statute, in clarifying what you mean by personally, isn't it obvious that the trial court personally addressed the defendant? I don't want to sound like I'm trying to ask a trick question, but if the trial judge personally addressed the defendant, then personally that began with the trial court. Isn't that right? The trial court personally said something.
I think, Your Honor, it's reasonable to infer that the trial court's language, you can waive your right to a jury trial, that maybe the trial court was addressing something to Mr. Rollinson personally. This gets me to the next point, that
Well, if that was a personal, was a comment directed to the defendant, does that satisfy the statutory requirement that the trial court make personal inquiry of the defendant?
that alone, Your Honor, does not satisfy
Okay,
the statutory.
tell me why. If you interpret the transcript to say that there's a question posed to the defendant, and instead the defendant's counsel responds, why does that not satisfy the statutory requirement?
Well, first, Your Honor, because the trial court isn't receiving a response necessarily from the defendant. And the whole purpose of the requirement to address the defendant personally is to determine whether or not the defendant understands the consequences of the waiver. I don't think you can get that from a third party. That the trial court must address the defendant personally, and that the defendant must personally respond to the trial court's inquiry. And again, here, saying something to the effect of, or you can waive your right to a jury trial, is not actually an inquiry. It's more of just a statement. And I think what you see afterwards sort of illustrates the confusion here. And even if this court does conclude that the trial court addressed Mr. Rollinson personally, and even if it construes the trial court's statement as a question, these together are insufficient to determine a knowing and voluntary waiver, and that Mr. Rollinson understood the consequences of his waiver.
Is your contention that the trial court did not address the defendant personally, or that the defendant did not respond personally himself to the trial court?
I think it's both, Your Honor. I think you can infer that the trial court addressed Mr. Rollinson personally in the first instance, although it's not entirely clear. But what comes after is no response from Mr. Rollinson himself. Thus, you don't have that sort of colloquy that we see in the other contexts where the trial court must, ask the defendant questions to understand whether or not the defendant appreciates the consequences of his waiver.
When you talk about a bright line rule, where would you have us to draw the line if, in fact, the counsel is there to represent the defendant, the trial court personally makes the statement during the colloquy to the defense table? At what point do we say that counsel no longer is in position to represent the defendant, and the defendant needs to represent himself or herself in his or her own voice?
I think, Your Honor, it's hard to say, that an attorney can't answer any question for a defendant, but we have drawn this line in other contexts, whether it's the right to counsel. There are cases where counsel had actually a fairly long conversation with the trial court about what he had advised his client, and that he thought it was a bad idea. And then the trial court, said, okay, whatever, sir, you can sit in your attorney's seat. And that wasn't enough, because there was no inquiry of the defendant himself as to whether he appreciated the consequences of that waiver. I think here, the bright line rule is that trial courts must establish knowing and voluntary waiver on the record through a colloquy with the defendant before they can consent to such waiver. Exactly how the minutia of that colloquy works, I think, is an open question, Your Honor.
How do you feel about what the Court of Appeals said, in that there is no script? And as a result, since there is no script for the colloquy, then the colloquy develops in the sense that the trial court determines what is sufficient to satisfy the statute.
I think this court could certainly continue to hold that there is no script. There is more of a script in the plea context. There is more of a script for the right to counsel context. But what we have in this case is really nothing. during the habitual felon phase as to a colloquy between the trial court and the defendant. So even if there is no script, it has to be something more than was here.
Well, what do you make of your colleague's suggestion that you can't just look at the interaction that occurred immediately before the habitual felon proceeding, that you also have to view the whole record, which includes the proceeding that happened before the bench trial started?
Well, Your Honor, I think I would just respectfully disagree.
All right, and tell me why you disagree.
Well,
with
the
this
habitual
argument.
felon statutes state that the habitual felon charges should be brought as if they were a principal charge. In fact, the habitual felon statutes state that even the charge of habitual felon should not be revealed in sort of presumed case to a jury until the jury has already convicted on the principal charges. So it's hard to say that Mr. Rollinson could have even waived his right to a jury trial in the habitual felon phase for a habitual felon trial that may not have even happened at the principal phase. But I think the statutes lay it out. They are separate proceedings and they should be treated separately so that what matters is what happened at the habitual felon phase.
If I understood the state's argument, and I may have misunderstood it, but if I understood it, they were not saying so much that there was a binding waiver of the right to trial by jury at both the guilt innocence phase and the habitual felon phase prior to the guilt innocence phase, but that instead, given what happened before the guilt innocence phase, you can assume that the defendant knew what he was doing, and therefore that provides some assurance that the waiver was appropriate. That seems to be the argument that I think was made in the state's brief. If it's not, I can be corrected, but assuming that's correct, what's your response to it?
Your Honor, I think that, again, because of the nature of the proceedings, that they should have been separate, and that although you could look to, what happened in the principal phase, we can't sort of, and this court has not allowed trial courts to presume a defendant's sort of assumed prior knowledge of what their rights were. Didn't let trial court do that even with a judicial official, someone you would presume, again, knows their rights. But even if you do include what happened at the principal phase in this case, the colloquy at that stage, although Mr. Rollinson isn't arguing was insufficient before this court, was very cursory. Also, the circumstances between the charges involved at the principal phase and the habitual felon phase are different, and the trial court did not inform Mr. Rollinson of that different nature. So I think even if you do include that first colloquy in the principal phase, it's not enough here to make up for the lack of any colloquy actually at the habitual felon phase.
To follow up on Justice Urban's question, it does appear in the initial waiver, which was the day before, with regard to the principal charges, that in reading those charges, they actually included habitual felon. And to the extent that the prosecutor then subsequently seemed to suggest to the court that the court didn't need to revisit it because there had been that previous waiver. Now, the court declined the prosecutor's offer of not revisiting it and did it anyway. But does that add to our analysis that the habitual felon charge was part of that initial dialogue?
I don't think it does, Your Honor. I don't think it would have been actually proper at that point to bring up the habitual felon charge as the habitual felon statutes lay out, that it shouldn't have at least been brought before a jury before they were convicted on the principal charges. And the habitual felon case number was not included on at least the first written waiver that would have included the principal charges. So I just don't think that whatever happened at the principal phase really influences the trial court's failure to establish a knowing and voluntary waiver at the habitual felon phase.
What weight should we give to the written waiver, since there was a written waiver on the principal charge? There were two written waivers. No, one written waiver on the principal charges, and then a second written waiver with regard to the habitual felon.
Your Honor, I don't think this court should give much weight to those waivers, the written waivers, at all. First, written waivers are not a substitute to the trial court's duty to establish a knowing and voluntary waiver on the record. They are something in addition to that. They can provide a presumption of knowing and voluntary waiver, but if the record reflects the opposite, that presumption is rebutted. And that's what we have here. Mr. Rollinson responded, or Mr. Rollinson's counsel responded to the trial court's statement that he was not requesting a jury trial and that he was comfortable with a bench trial. But Mr. Rollinson did not have to request a jury trial. That is the default under our Constitution. And his language of comfortable with the bench trial is more a language of acquiescence than it is asking for a bench trial. I don't think there's much weight to those written waivers. Really, they're there to memorialize what the trial court did, what the trial court's duty was to do on the record. And if you look at the language, record page 61, of what said happened in open court and what the trial court did actually did not happen, and did not happen to at least some extent in either the principal phase or the habitual felon phase. That brings me to what this court should do about this kind of error. Here, the Court of Appeals erred in requiring Mr. Rollinson to show prejudice because the trial court's failure to inquire and establish Mr. Rollinson's waiver was knowing and voluntary was central to the right to a jury trial and at least affected the very framework of the trial itself. Again, in such cases, this court applies error per se and does not require a showing of prejudice. And it does so not only to those issues central to constitutional rights. It does so even when a defendant could not show prejudice because higher considerations other than the outcome required. And those include the appearance of fundamental fairness and the adherence to constitutional protections. And here, the right to a jury trial is a fundamental bedrock constitutional right. North Carolina was the last state in the Union to even allow a waiver provision in its Constitution.
Are you saying that any deviation from strict compliance with the statute produces error per se, or are you saying something less than that?
Your Honor, I don't think the court has to say that and hasn't said that.
Well, in the
To
next
give
question,
Mr.
next
Rollinson
question is going to be if there's I'll let you have both of them in advance. The next question is going to be if there is strict compliance required, how do you square that with Hamer?
Yes, Your Honor. So Hamer presents sort of a different type of error, I would say. And in this court, Hamer held that where the trial court violated the waiver statutes by conducting an otherwise adequate colloquy establishing knowing and voluntary waiver on the record after the trial began, that violation was sort of purely procedural or technical that required showing prejudice.
What's the difference between a technical violation? I mean, how do we tell what the difference is between a technical violation and some other kind of violation that would presumably be error per se?
I think that can be difficult, Your Honor. I would say that
which is why I asked the question.
Yes, sir. I think that when the violation gets to the heart of the constitutional protection, and in this case, the constitutional requirement that this court has established for waiver of any constitutional right, and that's that knowing and voluntary waiver be shown on the record affirmatively, that's where you can sort of see the distinction. And I think this case provides a good distinguishing line between Hamer and this court's ruling in Hamer and the facts in this case to sort of, at least to an initial degree, show a distinction between a technical error and a substantive error. And again, here in Hamer, this court addressed a timing issue. But what was important was that the trial court actually conducted a colloquy and established a knowing and voluntary waiver on the record. But this court did recognize in Hamer that at that point, Mr. Hamer could have compelled a mistrial regardless of actual prejudice, and even with the advantage of knowing how the bench trial went. So the difference between Hamer, at least there was knowing involuntary waiver on the record. Here, we don't have that. And in fact, we have the opposite. Mr. Rollinson's counsel's response was more that he did not understand the very nature of his right, that he did not have to ask for a jury trial, that it was the presumed method for a trial under our Constitution. And this court doesn't have to disturb Hamer in order to grant Mr. Rollinson relief. It can merely clarify that some statutory violations are constitutional in nature and or can affect the framework of the proceedings such that they are error per se. And in doing so, this court can create a bright line rule for trial courts that they must establish knowing involuntary waiver on the record through a colloquy with the defendant before consenting to such waiver. And this court has provided the same clarity in the plea and right to counsel contexts. And your honors, even if this court requires a showing of prejudice, Mr. Rollinson was prejudiced because he did not understand the nature of his right, and he acquiesced to the bench trial, and because the wrong entity convicted him. Mr. Rollinson can't show the standard prejudice of a reasonable possibility that a jury would come to a different conclusion. And I think a lot of that inability to show that type of prejudice stems mainly from the nature of the habitual felon charges themselves. However, requiring a showing of prejudice in this context will affect this type of error in other contexts where the entity that convicts the defendant.
I hate to keep interrupting you, but one of the things that occurred to me is what is the question that we would ask in any harmless error inquiry that might be undertaken? Is it the typical one, is there a reasonable likelihood that the outcome would have been different? Or is it whether there's a reasonable outcome if the colloquy had been conducted as you said it should be, that the defendant would have not exercised his right to waive jury trial?
I think, Your Honor, that both of those are relevant. You know, obviously, the second one is
they're two different things. And
they are.
So if you were stuck with saying there is some prejudice inquiry here, what do we ask ourselves?
You can ask yourself either of those questions, Your Honor, and it's still hard to get to an answer on that based on the nature of the facts of this case and the habitual felon in general.
I've learned a long time ago that somebody once wrote, if you ask yourself the wrong question, you'll get the wrong answer. What is the right question here?
Your Honor, I think the question on the prejudice issue is really that, I guess I can answer it this way, and in this context, here, Mr. Rollinson can actually show the type of prejudice that this court would presume in a per se error analysis. And I think that fact shows that that actually should be the standard. I think if you're asking in a traditional sense what you should be looking for as far as prejudice, I think you could use either one of those or both of them to try and find prejudice. I think what's different about Mr. Rollinson's case here is that he can actually show that prejudice that you would presume. And here the trial court was confused about the very nature of the proceedings. At least 5 times the trial court said that Mr. Rollinson had pled to being an habitual felon, and the trial court even ordered the plea recorded. And the trial court persisted in saying that Mr. Rollinson pled to being an habitual felon even after the prosecutor tried to correct the court. Thus, the trial court rendered judgment in open court based on a plea that never happened. And this type of confusion would not have occurred with a jury present. And I guess that's the best I can do sort of to answer your question, Your Honor, although I presume that's probably not satisfactory. And if there are no more questions, I'll reserve the remainder of my time for rebuttal.
Thank you, counsel. Hear from the appellee.
May it please the court, I am John Congleton from the Attorney General's Office, specifically Assistant Attorney General representing the state in this matter. At the outset, this is an interesting case in the sense that this case came before the trial court, and initially in the guilt innocence phase, my understanding of the timing is the waiver of a right to a jury trial is still a relatively new concept when this is occurring. And the defendant approaches the state, I guess, saying, hey, we don't want a jury trial, we want to waive. And the prosecutor brings it up to the trial court, and there's some question about it. But at any event, the trial court then addresses them, personally in the guilt innocence phase, and they establish a waiver. Now, of course, defendant is subsequently convicted by the trial court, and then we move to the habitual felon phase. And this is interesting because at that time, the prosecutor indicates he's already waived. We contend we don't have to go through this again. The trial court itself says, no, this is a separate procedure, so we're going to go back through the waiver process. And at that point,
Do you agree that there needs to be a separate waiver in a case like this where you've got both the guilt innocence phase and a habitual felon phase?
Your Honor, that as an attorney, I think it is a much cleaner process to separate the two. And if I may explain my reasoning, because of the fact that a person might, at the outset of if the guilt innocence phase and the habitual felon phase are indeed two completely separate transactions, so to speak, a person could waive at the outset of the guilt innocent phase and potentially, depending upon what happens in the guilt innocence phase, decide, hey, wait a minute, maybe in this next phase, I don't want to be tried by a trial court. Maybe I really do want that. So I think if they are individual transactions, the safest course of action for any trial court is going to be to hold them separately in case there is a change of heart that occurs in the guilt innocence phase.
Assuming, putting best practice aside, under this statute, do you have an opinion, or does the state have a position as to whether you could waive a jury trial with respect to both phases of a bifurcated proceeding at the beginning?
I believe, Your Honor, that you could in fact do that and still satisfy the constitutional question of it being knowing, voluntary, and intelligent. Yes. But in this case, the trial court eclipsed that because the trial court revisited the issue as a separate transaction and said, hey, here we go. And he asks, and again, I would like to reiterate, he does not say, counsel, is he waiving his right? He says to the defendant, the jury's coming back in to hear this, or you can waive your right. It's very clear. It's not the counsel's right. It's Mr. Rollinson's right. And when the trial court says you and your, he is addressing Mr. Rollinson. And what is interesting here is Mr. Rollinson doesn't say, sure, I'm good with a bench trial. His counsel goes, they turn around, they have a conference. They discuss this. He discusses this with his attorney, his licensed, competent attorney. Based upon those discussions, the attorney says, hey, he's comfortable with a jury trial. The language, a little bit peculiar, granted, but it's very clear from the language used by the trial court that the trial court was asking, is this a waiver? The fact that his counsel says, well, he's comfortable with it, it was clear what the court was asking, and the answer is in the affirmative, despite the language being a bit peculiar. Furthermore, upon saying that, defendant himself does not say, wait a minute, that's not what I said, I want a jury trial. There's zero interaction from the defendant saying this isn't right, I don't agree, my counsel has, there's none of that. And most importantly, what we saw with the first waiver in the guilt innocent phase and what we saw in the second for the habitual felon phase is that defendant then signs the waiver of counsel form. And what's critical about that is, because we keep talking about vis-a-vis the colloquy and you must show on the record. We have on the record here a written waiver of jury trial form by the defendant, where the defendant specifically signs, and matter of fact, I'm going to pull it up here so I can quote the language correctly. Let's see, they're going to be E. One passed. The language that defendant signed says, I've been provided of notice of my intent in open court. He said, I've been informed in open court of the charges against me, the nature of the statutory punishment. I'm paraphrasing these a little bit, but I have a right to be tried by a jury of 12, that I can participate in the selection of jurors. I've been advised that if I waive this, the judge alone will find my innocence or guilt. I fully understand and appreciate the consequences of my decision to waive the right to be tried by a jury. And then beneath that, sworn, affirmed, and subscribed to me, the court clerk, signature of defendant.
And is the state's argument then that it is sufficient compliance with the statute to have a waiver of the right to jury trial form like this signed and nothing else?
Not specifically, no, Your Honor. But what I am saying is that when the trial court says, do you wish to waive your right, and gets an affirmative answer, and you have a defendant who, in this case, we know he spoke to his attorney, they conferred. Beneath that language I just read is the part where the attorney says, I discussed all this with him. And I won't read the whole thing there, but it basically reiterates all the things an attorney should speak to their client about. In the attorney's side, saying, I briefed my client on all of this. This is evidence that the defendant, and strong evidence, that the defendant knew and understood exactly what he was doing when he waived his right to a jury trial. Now, there may be a circumstance, Your Honor, where, let's say, the trial court comes in and does nothing. Let's just say the prosecutor says, well, he wants to waive his jury trial, and the judge says, okay, cool, we won't do a jury, and there's no colloquy. Well, then you're going to have a different circumstance than you have here. Now,
well, if we had that, just to understand the parameters of the state's argument here, if we had the situation that you just described, in your view, is that a valid waiver of the right to trial by jury under the statute and/or Constitution?
I believe so, Your Honor, in the sense that we know that his waiver was knowing, intelligent, and voluntary. We may have a statutory violation that the court can then look at, and the court can say, okay, well, the judge did not do the personal colloquy. So we know we have a violation of 15A12.1, but we have a violation of the statute. So the question becomes, is this, and I think this is the sort of the second part of the argument we heard before, are we now in a situation where we have to determine that this error itself was error per se, or structural error, where because of this error, there's simply no way whatsoever, the framework of the trial is such that there's no way there can be a fair outcome.
Before you go to prejudice, can I ask you what the implications of agreeing with you that all the judge has to do is say, you waive your right, does not need to hear anything verbally from the defendant. If we conclude that that is sufficient to address the defendant personally and determine whether he fully understands and appreciates the consequences of his decision to waive this right, wouldn't that then also apply to waiver of counsel and to every plea? And so when plea agreements are taken, the court doesn't have to hear from the defendant that he's actually pleading guilty and free and voluntary and understands he's waiving his right to appeal, as long as he signs a form and his counsel says, I've talked to him about it. Don't we have to apply the same standard in all three contexts?
Well, I think you are in all three contexts. Again, the facts of each case can be different, but in a circumstance where the judge looks at a defendant and does personally address a defendant, say, do you wish to waive? And the defendant says yes.
But here he didn't say, is my understanding. He didn't say anything.
Well, his counsel conferred with him as to the question and then informed the trial court. The counsel did not say, I am good with the bench trial.
But am I wrong? Don't we require in the waiver of a constitutional right to counsel or in the circumstance of taking a plea agreement that the defendant himself has to respond to the court?
In those contexts, I would submit they're different in the sense that in this particular instance, it's very clear that counsel is conveying defendant's position. Now, I think if it's very clear that we are dealing with the defendant's position and not simply counsel making decisions for their client, because the right ultimately belongs to the defendant. And a court may not, depending upon the circumstances before an individual case, a court may determine, I'm not going to accept that. That's simply not appropriate, because perhaps there's evidence in a record where maybe we're not sure what a defendant wished to do. But here we know, because he signed it under oath twice in 2 days, that he understood.
Right, but when the General Assembly was trying to figure out how to implement the new constitutional amendment, they came to the conclusion and put in the statute that the court should address the defendant personally and determine whether the defendant, not whether the defendant's attorney, but whether the defendant fully understands and appreciates the consequences. And that's language that appears in other contexts where we require that that a colloquy is a conversation, and that we require the defendant to himself say, yes, I understand, and the court to base its conclusion, because this is all under the section judicial consent to the jury waiver. The court has to decide, am I going to consent to this waiver? And how can the court do that without hearing from the defendant? At least hasn't our General Assembly said that they should hear from the defendant?
And it's my contention, Your Honor, pardon me, Justice, that the court did hear when the defendant signed the waiver. That is the defendant. His counsel can't sign the waiver form for him. There's a specific form. Defendant here signed. I know all of this, and I've done it. And I would contend that if the trial court addresses the defendant in open court, as it does here, do you wish to waive this? He says yes, and then signs this form, laying out all the niceties. I think that's sufficient evidence in the record, and it's sufficient to meet that burden and to satisfy the trial court. Because if the defendant didn't want to waive, the defendant would not sign the form.
All right, and my question is, if we agree with you, then wouldn't that also apply to any waiver of counsel and any plea agreement?
I don't believe that I would take the position that it would apply to all things. Again, I really think that there are circumstances where perhaps, I think there has to be circumstances where counsel can speak for their client in situations, especially where their client cannot, or there may be other issues. But I'm not necessarily sure I'm prepared to say that we would extend this beyond, because there may be circumstances where it's inapplicable. And I'm not, that case is not before me right now. So unfortunately, I'm not comfortable saying, let's apply this to all constitutional rights. No.
Right, but don't we have to understand the basis for the distinction? Otherwise, our decision would then apply generally.
I would not think that would be the case at all. I think in the case before you, we have all this evidence. He was addressed personally. He responded through his counsel orally and in writing, affirming that. And I think that's sufficient for this case and this right, based upon what's required for that to become a waiver of the right to jury trial, to be knowing and voluntary. So I don't think you have to extend it to everything. I think it's fine to keep it specifically to this right, because this court is distinguished, for instance, in things like improperly constituted jury, for instance. You're not going to treat those two things the same way. I think the court has treated those almost as structural error regardless, because there's.
So are you suggesting then that the right to a jury trial in our Constitution is not as weighty or fundamental as the right to counsel or the right to appeal that you give up when you enter a plea?
Absolutely not. The argument, of course, is that when you have this, whether you have error, for instance, what level does that go to? An error in structural error, if you will, where there can, no matter what happens, there could not be a fair outcome, then of course not. But in cases like this, you can have technical errors that occur that are not going to rise to that level, and you may well have a prejudicial analysis based on that. But
let me ask you one. Again, I'm trying to understand the extent to which your argument goes. We've got the quotation at from the transcript that says, "Trial court, I'll do that at this point. At this point in the trial, it's a separate trial. The jurors are coming back to hear the habitual felon matter, where you can waive your right to a jury trial and we can proceed." And then we have the indication in the transcript that counsel asked permission to speak with the client, spoke with the client, and then indicated that the client waived it. If there was no evidence in the transcript that such a conference between the counsel and the defendant occurred, so that after the trial court statement, counsel said, Your Honor, we can proceed, or something like that. No indication of consultation with the defendant. Is that a valid waiver of the right to trial by jury, even if there's a signed waiver of counsel? Waiver of trial by jury in the file?
I think at that point, Your Honor, you may well have a very clear violation of the statute, and then whether it rises to the level of a constitutional violation where the defendant, if the defendant intended to waive and it was knowing and voluntary, then perhaps there's not. But that being said,
you emphasized difference between the statutory and the constitutional violation several times. The constitutional provision, I think, I don't have it in front of me, says that the waiver should be addressed in the form prescribed by the General Assembly. Mm-hmm. So that, to some extent, could be construed to merge the two, couldn't it?
well, when you get to this point where there's a violation of the statute, you have to look at the facts and circumstances to determine the nature of the error. And is the error technical, or is the error actually, I'm going to use this term badly out of context, but substantive in a sense, that we know that because of this error, there was this outright violation. We know that because this error, the defendant did not knowingly, voluntarily, intelligently waive this right. And in a circumstance where there is no evidence in the record, then perhaps that's a factual determination where the court says there's no evidence in this record that the defendant ever intended to knowingly, voluntarily, or intentionally waive this right. And in that circumstance, then you might then get into the analysis of, if you have this where the trial court, again, I'm using some terminology here, but where the trial court has deprived the defendant of that choice of that right at the outset, then perhaps then you get into, this is now structural, because there cannot be a fair outcome where the defendant is sort of deprived of this right completely. In this case here, and if I may, quote Hammer, I believe it was, Hamer, as the court indicated, the defendant complains that the trial court denied him a jury trial he didn't want. And here we know we've got that because he was addressed the day before in guilt innocence. He was advised the same the next day, an habitual felon. He asks, they confer, his counsel responds, this is fine, paraphrasing. And then again, he signs the waiver. And it never indicates he doesn't want to do this. There's no ineffective assistance of counsel. There's no MAR. There's none of that. Defendant apparently was happy with the way that occurred at the time. And so I think we have a technical error here, if there is an error, because basically it's clear from the record, there's overwhelming evidence in the record that the defendant was advised of these things, signed off, and was good with waiving that right.
Let me add, and I'm going to stop interrupting your argument here for a second and let somebody else talk. But I want to ask you the same question I asked, is if we get to a harmlessness inquiry here, what is the question that we should ask ourselves? I think I gave him two possibilities, and he said both. One being, is there a reasonable likelihood the outcome of that the hearing would have been different, or is the inquiry, is there a reasonable likelihood that the defendant would have waived the right to trial by jury?
I believe, Your Honor, that I see both of those questions as being necessary in a case, either or. In the sense, as I was just talking about, whether or not in the first instance, do we really have this violation? And then if so, which path do we go down? But if we have this violation here, I think the proper standard is prejudicial error, in the sense of, if we look at the error and go, this is, using the terminology from Hamer, a technical error, then at that point, we're just looking at prejudicial. If you have a situation where the court looks at the error and says, and I'm going to use the analogies of the improperly constituted jury, where this has to be structural, then maybe that question answers the analysis. But if you're looking at this going, yeah, this is kind of a technical thing, then the operative question becomes, was there prejudice based on that? And in this case, there was. I don't think there was any prejudice. I've argued in my brief. I would contend that, of course, he waived it. But B, when they the state put on the evidence of the 3 judgments of the prior felony convictions, the defendant's defense to this essentially was, yeah, I've been convicted of those 3. My strategy was I was going to try to go in and get one vacated, but I didn't do it. So there's no prejudice there on a technical violation of the statute, because I just don't see a reasonable possibility for one, in the sense that there's only a technical.
A reasonable possibility of what?
Of there being a different outcome based upon the total, I'm not going to say acquiescence necessarily, but the total lack of any defense to that, other than to say we had a strategy to vacate one of them and didn't. It's almost an admission in a sense. But my point is, if you have this technical violation where you say, well, the judge should have had the defendant himself answer the question rather than his counsel, but we've got this evidence in the record that he did intend to waive, and there's no reasonable possibility a jury's going to do anything different with this, considering the essential acquiescence to the judgments. Then at that point, I think that's the end of the analysis. There's no prejudice here in that regard. Now, again, if this was an improperly constituted jury, which I think this court has looked at in those and said, from the moment that happens, the whole structure of the case is bad, then how can you go in, for instance, with, well, and this court has, I think, said pretty much in those cases, that's going to be per se, because at that point, no matter what happens, you can't cure it. There is no cure for that. But this is different.
Throughout your conversations with Justices Irvin and Earls, you've emphasized the aspect of the written waiver. The colloquy is independent of the written waiver, and I know how you're talking about how the written waiver, while not in the stead of the colloquy, nonetheless can buttress it. But in terms of having a meaningful colloquy, even with a written waiver, isn't it effective for a colloquy to have the defendant to say in his or her own voice that he or she understands what's in the written waiver and understands everything that's going on with fully understanding and appreciating, because only the defendant himself or herself can say what truly he or she fully understands or appreciates?
And getting back to the beginning, I do think that the best practices would be not necessarily voluminous, but a more detailed colloquy is certainly going to be better all the way around. And for instance, having the defendant answer directly, but we don't really know, the defendant may not be as easy in speaking back and forth. I don't know. That's something that's not in the transcript. Maybe the defendant's shy. Don't know. I agree with Your Honor that the very best way that this could work out would be to have a very detailed colloquy, and it be, the defendant specifically saying, yes, absolutely, I understand this point. Yes, I do. But I don't know that that's a requirement under that may be, sort of what you want to see, but I'm not sure it's a specific requirement. The language in the statute itself to me is a bit strange, and it just says, address the defendant personally to determine if they knowingly involuntary. If the trial court were to say, would you like to waive your right or whatever, and the defendant says, well, I've read the form here, so I'll sign that. I don't think written necessarily violates it. I do agree that it's much cleaner if the defendant does this on the record, on the transcript, in his or her own words.
Let me ask a follow-up on that. The statute also requires that in the addressing the defendant, that the trial court determine that the defendant fully understands and appreciates the consequences of his decision to waive a jury trial. And here, what colloquy there is, the judge asks him or says, well, the jury's going to come back and they're going to hear your case, or you can waive it. In Hamer, what this court approved the trial court gave much more detail about, went on to say, and you understand the charges and the penalty can possibly be Is that a meaningful distinction to the state, or do they not need to, the trial court does not need to say anything about what the consequences are in terms of the charges or punishment?
Well, it's interesting in the sense that the trial court is asking that question. The trial court knows and sees, well, the trial court did a little better colloquy in the first day. But on the second day, and probably with that sort of background, asks, okay, we're going to do the same thing as yesterday. And he confers with his counsel. He's already signed one waiver. He's willing to sign another waiver. If the person is willing to sign the waiver in those circumstances, can the trial judge say, that satisfies me that this defendant does understand, because they have been briefed. They have signed the waiver before. They are familiar. It's the very next day. They're not objecting. That being said,
But what does that tell you about his understanding of the consequences of that decision?
Well, I think that the defendant understood the consequences because he was briefed. He did speak with his attorney there, and he's raised no objection to that. The defendant's not spoken and said, hey, on second thought, I didn't understand. The defendant hasn't popped up and said, ineffective assistance of counsel. They never explained to me the difference. And his counsel signed under oath that they had explained all this. The evidence in the record is that he was briefed. He did know, he did understand, and he willingly signed that form under oath, affirming that. And that evidence is in the record before this court. It was a knowing and voluntary waiver. Despite the trial court's short shrift given to the colloquy. We could have a better colloquy, of course, but obviously we're stuck with the record before us.
Are you saying that we should give some weight to the fact that in terms of the temporality of the second segment of this matter, the habitual felon aspect with the first one, the substantive one just the day before, that should be given some weight in terms of at least the recency of what had been occurring the day before, in terms of how the trial court, perhaps in some level of discretion, should arguably there have been some discretion to see some linkage between the first day and the second day?
Well, and I do think it goes to that facts and circumstances in the determination of does this defendant know and understand this process of waiving and what's at stake? And I think that is evidence that he does, because it is close. It was done on the record the day before. We are following up, and he's read. We know that he read and signed this information on this waiver, which contains all of it the day before. He's aware of what's there. And the defendant never says, wait, I don't want to do this. There's zero evidence anywhere that the defendant, this is not exactly what the defendant wanted to do and did. And so therefore, I do think it goes to that analysis that a court must do to determine, again, is there this sort of, he doesn't know, he didn't understand. We've got all this evidence. Seeing no further questions, I would ask this court to please uphold the lower court's opinion. Thank you.
Thank you, counsel.
Thank you, Your Honor. Just a few quick points. So I think where a lot of the rub is here is what type of error this was. My colleague here says that it's just a technical violation, purely statutory in nature. However, again, this court has time and again, in the waiver context, said that establishing or affirmatively showing a knowing and voluntary waiver on the record is a constitutional requirement. So I think this case shows constitutional error. And even if it doesn't, because the wrong entity convicted Mr. Rollinson without a knowing and voluntary waiver, it affected the very framework because the wrong entity was there to hear the case. And again, we don't know what Mr. Rollinson's attorney said to him during their conversation. And the language in the attorney's answer only reflects that Mr. Rollinson may have misunderstood his right to begin with. And I think what's important is the trial court statement, again, was the ultimate question of whether or not Mr. Rollinson wanted to waive. but it had no foundation for whether Mr. Rollinson's waiver was knowing and voluntary. And if you look at the written waiver, nothing, at least in this habitual felon phase, nothing that waiver says the trial court did in open court actually happened. And this court requires more in the right to counsel in the plea contexts. The language of Section 15A 1201 isn't so strange. If you look at 15A 1242, the statute on a defendant's election to represent himself at trial, it says that defendant may be permitted at his election to proceed without the assistance of counsel after the trial judge makes thorough inquiry and is satisfied that the defendant has been clearly advised of his right, including assignment to counsel if he's entitled, understands and appreciates the consequences of his decision, and comprehends the nature of the charges and proceedings of range of possible punishments. This court before has held that the trial court must conduct this colloquy and get responses from a defendant before it can consent to the defendant's waiver of the right to counsel. And I think in requiring a lot less of trial courts in this context, whether intentionally or just by practice, actually does start to stratify these rights, which I don't think we should do. I'm not saying that there is a specific script that we must adhere to on the right to a jury trial waiver. But what has to happen is more than what happened in this case, which is tantamount to nothing. And in conclusion, Your Honors, the trial court violated the statute mandating a colloquy with Mr. Rollinson before consenting to his purported waiver of a jury trial. As a result, the record does not affirmatively show a knowing and voluntary waiver. In fact, it shows the opposite. Therefore, the trial court's error is error per se. Moreover, this court should reaffirm the notion that substantive statutory violations, which affect the fundamental framework of a trial, are error per se. And in doing so, this court can provide a bright line rule to trial courts that they must establish knowing and voluntary waiver on the record through a colloquy before consenting. Mr. Rollinson respectfully requests this court reverse the Court of Appeals and vacate the habitual felon conviction. Thank you.
Thank you, counsel. Thank you to both counsel. Mr. Clerk.
All rise. Oh yes, oh yes, oh yes. The Supreme Court of North Carolina will be in recess until 1 p.m. God save the state and this honorable court. Honorable, the Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes. The Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Good afternoon, everybody. Welcome to the historic 1767 Chowan County Courthouse. By the Constitution, the Supreme Court of North Carolina is to hold court in Raleigh and such other places as designated by the General Assembly. In 2004, in recognition of the restoration of this beautiful facility, the General Assembly designated that the Supreme Court of North Carolina could hold court here in Edenton. And we are grateful for that, and certainly grateful for all the folks here in Edenton who have done so much to welcome the court. The case we have this afternoon is Holmes et al. Versus Moore et al., and we will hear from the appellant.
Good afternoon, Your Honors. May it please the court, Pete Patterson for the legislative defendants. We are sharing time with the state board defendants who will get 7 minutes, and I would like to reserve 5 minutes. The Superior Court's determination that SB 24 was motivated by a desire to entrench Republicans by targeting African-American voters is unsupportable both as a matter of law and as a matter of fact. And for those reasons, the Superior Court's judgment must be reversed or at a minimum remanded for application of the correct legal standards. With respect to the facts, there are two in particular that demonstrate the unsoundness of the Superior Court's ruling. First is that 5 Democrats voted for SB 824, and there is no explanation for why 5 Democrats would vote for a bill designed to entrench Republicans. And the Superior Court had no explanation for that fact. The second is the sweeping reasonable impediment provision, pursuant to which SB 824 goes out of its way to ensure that all voters can vote, regardless of whether they have a voter ID. Now, the Superior Court mentioned that the General Assembly was told that under the prior voter identification law, HB 589, 184 out of over 2 million voters did not have reasonable impediment ballots counted. First of all, 184 is not much of a basis upon which to build an entrenchment theory, but there's more than that. The General Assembly took at least 6 steps to drive that number lower. First is the expansion of the number of qualifying IDs, adding student IDs and state and local government employee IDs, which the General Assembly was criticized for excluding from HB 589 because they were disproportionately held by racial minorities. But also was the creation of the free, no documentation voter IDs available at early voting locations in each county, which again is disproportionately used by African Americans. So no General Assembly intent on entrenchment would do that.
Let me ask
Yes.
you a fairly basic question
Yes.
before you get too much further into your argument. Do you contend that any of the majority findings of fact lack sufficient evidentiary support?
Yes, and first of all, the ultimate finding of fact, which is that this
Well,
was
I
based on.
understand that you're
Yes.
challenging the legal conclusion.
Yes.
And so are there any of the specific evidentiary findings of fact that you are contending lack sufficient record support?
Yes, I would
Okay.
say that each of the predicates to the ultimate, for each of the Arlington Heights factors, competent evidence does not support those. And also, particularly in paragraph 111, the Superior Court got basic facts about the voter ID law incorrect. So this is in discussing public assistance IDs. And the Superior Court said, well, there's no explanation for why you would accept federal government employee IDs, but not public assistance IDs. But the law does not accept federal government employee IDs. So the Superior Court got this basic fact about the law incorrect. And the evidence in the record, Professor Callahan indicated that federal government employee IDs are disproportionately white. So the exclusion of those does not bespeak any discriminatory intent. But of course, we're also challenging the legal predicate upon which the court based its decision, and that it did not.
And I'm clear on
Okay,
that. I mean, I
okay.
understood that. I was trying to understand whether what we had was a challenge to any discrete finding of evidentiary fact, not the application of the Arlington factors, not the ultimate conclusion, but just the evidentiary facts.
Right.
You've mentioned 111. Were there any others?
In paragraph 111, they also said that the eligibility period for the free no documentation voter ID is 1 year, when in fact it's 10 years. So that's another basic error of fact. But in terms of, what happened, other than those things, the provisions of the bill, the legislative record is all, a matter of public record. So I think.
So is it fair to say, and I'll stop interrupting you a second and get the preliminaries out of the way. Is it fair to say that with the exception of a couple of things that you've indicated, your argument is really either that the applicable legal standard was misapplied and or that the Arlington Heights factors were misapplied?
Yes, Your
That's
Honor.
essentially what we've
Yes,
got.
that's essentially what we're arguing, and that there's not competent evidence to support the ultimate conclusion, and apart from that, the incorrect legal conclusion was applied.
Thank you.
But as you responded to the question, it seemed to me that you also contested findings of fact based on various testimonies of certain of the plaintiff's experts that I believe you said that one didn't take into account the sweeping reasonable impediment provision. I think that was Dr. Quinn. I think you indicated that others did not fully consider the breadth of what was available, and whatever testing they did seemed to have been in response to the prior House bill, not updated to reflect the changes in Senate Bill 824. Is that accurate?
Yeah, that is accurate. I guess it's a bit of a challenge here to say what is a fact and what is a legal conclusion, because like I said, the basic historical facts of what happened, that's all a matter of public record. Now, what inferences you draw and, whether you credit experts' testimony or not, it's set out in the briefs that we don't accept all of those things. For example, Ms. Ferris's testimony, it was not competent to support a finding that this was an anomalous activity. I mean, she specifically said that nothing in her testimony addressed the issue of racial discrimination, and nothing in her testimony could distinguish between what the General Assembly did in SB 824 and the other 9 or 10 bills that they passed in the lame duck session. And we don't concede that, Professor Quinn had an accurate picture of the voter ID possession among the electorate. And getting back to where I started in terms of things that the General Assembly did to make this even more protective of voters than HB 589. So there are at least 6 changes. One I mentioned was the additional IDs. Another was the expansion of the reasonable impediment process from people who had an impediment to obtaining an ID to people who had an impediment to presenting an ID. So for example, now people who forget their ID at home would have that process opened up to them. There was an elimination of the requirement to present an alternative ID in order to have a reasonable impediment ballot count. There was eliminated ballot challenges to reasonable impediment IDs, and they also got rid of subjective reasons to discount reasonable impediment ballots. And then finally, the 6th thing is mandated education. There were 4 mailings that were required to be sent to every household in the state, stating that all voters can vote with or without ID. So as the district court in the District of Columbia, in pre-clearing a South Carolina voter ID law, said a sweeping reasonable impediment provision, expansion of number of IDs, making it easier to obtain IDs, and mandated outreach and education all undermine any finding of racially discriminatory intent, and all of the same is true here. And the Superior Court ignored these changes. And that's the legal error that we point to, is that the Superior Court essentially flipped burden of proof and presumed bad faith on behalf of the General Assembly.
Before we turn to the legal
Yes.
error, sticking with the facts in North Carolina for just a moment, The trial court, in addition, so you mentioned the 184 reasonable
Yes.
impediment
Yes.
ballots in the May 2016 primary, which was the only time the reasonable impediments process was used. But the trial court also found that during that March 2016 primary, 1,248 voters without acceptable photo identification, provisional ballots, didn't have the reason, didn't, for whatever reason, and there's also testimony in the record of individual voters about that they weren't offered, they came to the polling place without an ID, they weren't offered in that March 2016 primary a reasonable impediments affidavit. But 1,248 voters, the trial court found, did not have the reasonable impediments declaration, they didn't otherwise cure their provisional ballots, and those votes were not counted in that election.
Yes, and again, that is less than 0.1% of the ballots that were cast in that election, and the changes that were made would assist those voters as well. For example, there's a specific provision now that says if someone shows up with that ID and they cast a provisional ballot, they have to be given a piece of paper saying, okay, here's what you need to do to cure that provisional ballot, to make sure that if for some reason there was a polling error, trying to combat those. In addition, since the reasonable impediment process, again, is expanded from an impediment to obtaining an ID to impediment to presenting an ID, if the problem was people forgot their IDs, again, those persons now would be able to cast a reasonable impediment ballot. And for those people, we don't know why. There's nothing in the record saying why they didn't come back. They could have come back and shown an ID at the Board of Elections office within 10 days, and they didn't. Perhaps just the elections were not close enough, and they just thought, I'm not going to go through with the hassle. So there was nothing in the law that prevented those people from voting, and that's why we focused on the 184 and the multiple steps that were taken to drive even that number down.
But that information, the facts about the changes that you just identified, that was all before the trial court.
That was before the trial court, but the trial court ignored those facts.
But you're asking us to reweigh the evidence that the trial court had and come up with
No, we're not asking you to reweigh. We're saying there's not competent evidence to support the legal conclusion that this was made for a racially discriminatory purpose, similar to the Fourth Circuit in McCrory, was operating under a clear error standard, which is higher than this court's, more deferential to the trial court than this court's competent evidence standard. Yet that court reversed a trial court finding that there was not discrimination in HB 589. And so the same way this court can find no competent evidence. But again, it was built on a faulty legal foundation. And that is shown by the emphasis on McCrory. There are nearly 50 citations to McCrory in the Superior Court's decision, but not once does the Superior Court mention that the same Fourth Circuit actually held that SB 824 was likely not racially discriminatory, unlike HB 589. And this is a court that is bound by the prior McCrory decision. That, and yet that's not mentioned one time. The court also does not mention that President Carter and the Carter-Baker Commission recommended a strict voter ID law. North Carolina's law is non-strict, which means that people without ID can show up on election day, fill out the reasonable impediment form, and they don't have to go back to an elections office or do anything else to make their vote count. President Carter had recommended a strict voter ID law with only 2 forms of ID. And if someone, after a phase-in period, if individuals showed up without ID, they would have to return within 48 hours with an ID in order to vote. And federal courts have upheld from constitutional challenge strict voter ID laws on that model from places like Wisconsin, Indiana, Virginia, and Georgia. And yet the Superior Court ignored all that.
Are the different factors in Arlington Heights to be given any particular weight, or can they all be equally weighted?
They can all be equally weighted. Arlington Heights it's the factors are just in aid of the ultimate legal determination, whether there was racial discrimination. So it's not a checklist. It's not one's weighted one way or the other. It's just ultimately an aid to making this determination. And our submission is that they do not show the Arlington Heights and the ultimate facts, even apart from the Arlington Heights factors. Just if you step back and look at it, why would 5 Democrats vote for a law meant to entrench Republicans? Superior Court had no explanation for that. Why would a General Assembly go out of its way to make sure everyone can vote if it was intending to prevent some group of people from voting? There is no explanation for that.
In terms of some of that, which you said, in terms of looking at the factors in Arlington Heights and looking at some of what you've said as well about such things as the Democrats that voted for the Senate bill, wasn't there some aspect, for example, concerning the fact that some of the aspects of the bill weren't fully populated, such as, for example, what IDs would be accepted, and perhaps some Democrats voted for some things that had not been fully vetted or otherwise had not been fully divulged or otherwise developed?
No, Your Honor, 4 of those Democrats voted for the final version of the bill. The only one that didn't was Senator Ben Clark, had voted for it in second reading out of the Senate, and then was absent from the concur when it came back from the House. But the other 4 Democrats, Senator Ford, Senator Don Davis, and Representatives Hall and Goodman, all voted for the final version of the bill. They didn't all vote to override the veto, but they all voted for the bill in its final form.
And what level of weight would be given to the legislative history in terms of looking at this question concerning a discriminatory intent, in terms of looking at the history, such as from McCrory and some of the other aspects that the trial court considered?
Well, you can't presume bad faith on the basis of a past discriminatory act, and that's what the Superior Court did here. They said, and the Superior Court said in the paragraph, in the heading before paragraph 110, that the design does not evince an intent to cure the racial disparities found under HB 589. Of course, as I just mentioned, there were several things that were designed to cure any disparities that possibly could be found, but that's not the test. In the Abbott versus Perez case, that's the exact type of language that the Supreme Court of the United States said does not show a sufficient presumption of good faith, when the Texas District Court in that case said that the design did not show an intent to cure a prior taint. And so that was legal error. Also, in paragraph 231, the Superior Court said that 62 members of the General Assembly voted for HB 589 and SB 824, focusing more on who they were rather than what they did. And in that same paragraph, there was a discussion of a presentation by then Executive Director Strzok, who had said that potentially hundreds of thousands of voters lacked ID and that the General Assembly was told this. But what the Superior Court ignored was that in that same presentation, Executive Director Strzok said that in mailings to these individuals who had been identified from database matching lists, the vast majority of them that responded to those mailings said they in fact did have qualifying ID, 91% in one mailing and 76% in another mailing. So completely undermining the validity of these sort of database matching exercises.
And why you say that the trial court, to use your term, ignored it, isn't it in the record for the trial court to consider whether or not it is worthy of the same balance under Arlington Heights as some of the other matters, such as the bad faith that was evinced in the legislative history, and give that whatever weight it chose?
Well, I use the word ignored. I mean, it's ignored in the opinion when it speaks of that very presentation and highlights that there were hundreds of thousands of individuals that were not matched in database matching exercises. But then within that same presentation, indication that the vast majority of people that responded to mailings regarding those no match lists indicated that they in fact did have IDs. So that's a very pertinent fact that would affect the competent evidence analysis, but also just shows the presumption of bad faith at every turn. When there was perhaps an inference to be drawn, it was a consistent presumption of bad faith. And the public assistance IDs show that very clearly. When the Superior Court said, well, it evinces bad faith to reject these public assistance IDs, although the Fourth Circuit in Raymond, looking at the same legislative record, said nothing in the exchange evinced bad faith. But then the Superior Court also said, well, the later addition of public assistance IDs does not give any credit to the General Assembly because, as far as we can tell, there are none of these actually exist. So how can it be both ways? That just shows they're presuming bad faith. And in addition, with respect to the IDs, the plaintiffs have not identified any array of ID that could narrow the alleged disparity that exists here at all. So as far as the evidence before the court shows, this is the array of voter ID that would have the narrowest possible racial disparity. And then plus we have the reasonable impediment provision. Again, the plaintiffs haven't shown that there's anybody that would not be able to vote under this law.
But when you use the term ignored, just to make sure I'm clear, when you say ignored, you're not saying that the trial court didn't consider it, but you're saying, if I understand you correctly, that it is just not mentioned in the opinion in the factors which you've conceded the trial court could balance those factors the way that it saw fit.
Yeah, well, I don't know what went on in the drafting process or what was in their minds. It was in the record. It was not reflected in the opinion. So that's what I mean by ignored, Your Honor. And I'm into my rebuttal time. I'm happy to answer other questions or preserve my time. Thank you.
Good morning, and may it please the court. I'm Carla Babb with the North Carolina Department of Justice here on behalf of the state defendants. With me is Laura McHenry, also with the North Carolina Department of Justice. Your Honors, with the short time that I've reserved here today, I wanted to discuss the disparate impact analysis of North Carolina's voter ID law under the Arlington Heights inquiry and evidence at trial about the State Board of Elections' role in the enforcement of the challenged law. The application of Arlington Heights in the cases from the federal circuits informed that what is relevant to the discriminatory impact analysis is the provisions of the law themselves. And with voter ID laws, we know what is very important is looking at whether the laws have ameliorative provisions and what those ameliorative provisions say. As state defendants fully argued in their briefs presented on appeal, plaintiffs failed to present evidence to establish North Carolina's current voter ID law violates North Carolina Constitution. The trial court erred in several aspects of its analysis, and the court should reverse the trial court's order. However, the most fundamental flaws in the plaintiff's arguments and presentation of the evidence and the trial court's order are reflected in those parts of the order pertaining to the photo voter ID law's ameliorative provisions.
Ms. Babb, let me ask the same question of you that I asked of Mr. Patterson. Do the state defendants contend that any of the trial court's evidentiary findings lack sufficient support, or is your argument more directed to the ultimate fact and legal conclusion determinations that the trial court made?
I think our argument points more to the ultimate conclusion, but in our brief, we did challenge some of the findings of fact. So just for example, that I have here is some of the findings of fact dealing with Dr. Quinn's testimony in findings of fact 130 to 134 and 141, and then the findings of fact that concern Dr. White's testimony, which are 160 to 161, but primarily we've argued legal errors and, yes, Your Honor.
Okay, thank you. That's helpful.
The trial court erred in assessing the ameliorative provisions, and Mr. Patterson has covered some of that, but I just want to highlight a couple of things. The first way it argued, and again, Mr. Patterson touched on this, was that it ignored the weight of the authority from the circuit courts that demonstrate voter ID laws with ameliorative provisions similar to ours reduce any potentially disparate impact sufficiently to overcome an equal protection challenge. And those are the cases from Virginia in the Fourth Circuit, Lee, Alabama, Greater Birmingham, Versity from Texas, which was a Fifth Circuit case, Frank, which was a Seventh Circuit case. In those cases, they had similar provisions to ours. But the courts there found there was no discriminatory impact and ultimately no equal protection violations. And among other notable characteristics of those laws is that they either didn't have a reasonable impediment provision, or if they had one, an extra step had to be taken to be able to vote, which is not what we have here in our law. And in those cases, the court still found that there was no disparate impact and ultimately no equal protection violation.
But shouldn't we be looking to the findings of fact and the evidence about disparate impact in North Carolina? And in particular, for example, let me draw your attention to finding of fact 141, where the court said, this court finds that Professor Quinn's results are reliable and establish that African voters are more likely than white voters to lack a form of qualifying ID under SB 824. Isn't that a finding of fact by the trial court based on hearing all the evidence, hearing the conflicting expert witness testimony, making his findings based on the evidence, isn't that a finding of fact that we're bound by?
Well, that finding, I believe, was challenged by both the legislative defendants and the state defendants. But even assuming that is true, the ameliorative provisions are important to look at to see that they reduce any potential disparate impact from the fact that one set of the population may possess more of the qualifying IDs than the other set of the population.
But aren't we looking, under the Arlington Heights factors, aren't we looking at this disparate impact evidence in order to determine ultimately whether there was a racial motivation in passing the law? Isn't that the purpose of this evidence?
Yes, Your Honor, it is. But when you're looking at disparate impacts, let's take that as true. Let's say despite the challenge to it, one part of the population carries more of the ID, possesses more of the IDs than the other. Well, then you look at the reasonable impediment provision, and it substantially reduces any burden to the population that has less of the qualifying IDs, and the case law from these other circuits say that it doesn't have to, as the trial court seemed to believe, eliminate the burden completely, because we know that from these other case laws, the existence of some level of inconvenience in the voting process does not prove discriminatory impact, even assuming that there's a disparity in some who may have the inconvenience of obtaining a free ID or the inconvenience in voting with no ID, and those who do not. We know that from looking at the Fourth Circuit's decision in Lee, where the court recognized that Virginia did have a disparity, as what you're recognizing there, Your Honor, but said because Virginia had offered free identifications and had a cure process for provisional ballots after the election, much like North Carolina does, of course, we go a step further, that law is not discriminatory, as Virginia went out of its way to make the impact as burden-free as possible. It was the same analysis with the Versailles Court, the court in Frank, and then with the Fourth Circuit analyzing our law, this particular law. All these relied upon a U.S. Supreme Court, granted not an equal protection case, but the Supreme Court case in Crawford v. Marion County Board of Elections that says things that you must do to obtain an ID do not qualify as a substantial burden on the right to vote or even represent a significant increase over the usual burden of voting.
I guess I'm asking a slightly different question in the sense that it's my understanding that the trial court's order, the reason why it was significant that so many legislators had voted on the prior bill was because it was about their knowledge about the impact on voters and who had IDs and who didn't. And ultimately, under Arlington Heights and under the disparate impact prong of proof under Arlington Heights, it seems to me it doesn't matter whether the legislature ultimately was right or wrong. It was what was in their minds. What were they intending? What impact would they naturally expect? And so the fact that they had voted on a prior law, they knew that African-American voters were more likely to lack an ID, that's relevant to what their intent was, whether they were actually at the end of the day absolutely right about it.
Well, all of it, it just factors together. And if you look at the law, that's what's primary you should look at. This is a facial challenge, and the resulting disparate impact is helpful and informs the intent here. And it is. I'm not saying it's the only part, but it's just one part. And in this particular case, it is clear when you look at the disparate impact analysis that there was no equal protection violation here, along with all of the other factors. So it's a multi. I'm not saying disparate impact is the only thing you look at. You have to look at everything. But if you do look at everything, we'd ask that you reverse the trial court's ruling. Thank you.
We'll hear from the appellate.
May it please the court. My name is Jeff Lupito. from the Southern Coalition for Social Justice and the Durham Bar. I represent plaintiffs, appellees, Barry Holmes, Fred Culp, Daniel Smith, Jaden P.A., Paul Kearney. Following years of litigation culminating in a 3-week trial, the majority of a 3-judge panel concluded that Senate Bill 824 violated the North Carolina Equal Protection Clause because it was enacted with the intent to discriminate against African-American voters. The question before this court is whether that conclusion is supported by findings of fact based on competent evidence. And the answer to that question is an unequivocal yes. The 102-page majority opinion details at length the substantial competent evidence put forth by plaintiffs to satisfy their burden under the Arlington Heights burden shifting framework. That evidence, considered under the totality of the circumstances, supported the trial court's final determination that the Republican supermajority enacted Senate Bill 824, at least in part, to entrench itself by burdening the voting rights of African-American voters who in North Carolina reliably vote Democratic. It was then and only then that the trial court shifted to defendants to demonstrate that Senate Bill 824 would have been passed without discrimination as a motivating factor, a burden they were unable to carry. Defendants, not surprisingly, take issue with some of the inferences drawn by the trial court based on this evidence, and their briefing is filled with countless examples of where they believe the more plausible interpretation is one in their favor, and you heard about them in their opening argument. And they come here today requesting that this court partake in that same exercise, but it is not the function of this court to reweigh that evidence. And as this court has repeatedly stated, a trial court's finding of fact are conclusive on appeal if there's competent evidence to support them, even though the evidence could be viewed as supporting a different finding. And that makes particular sense here.
Do you agree that the trial court was required not to overemphasize the prior House bill and whatever may have attached to that?
Yes, Your Honor. I agree that the trial court was not permitted to shift the burden of proof, burden of persuasion onto defendants. It was plaintiff's burden to present evidence with regard to the Arlington Heights factors, the subjects of inquiry there, the sequence of events, the legislative history, the law's impact, and the historical background. And that is what plaintiffs did here. They put forth evidence on each of those factors, and the trial court considered those factors in the totality of the circumstances before reaching its ultimate determination of discriminatory intent.
Well, if the trial court made 50 references to the Virginia or the Fourth Circuit Court of Appeals decision in McCrory and no references to the current Fourth Circuit case that considered the bill that was actually before it, what should this court make of that?
Well, for starters, this court is not bound by any federal decision. As Your Honors know, and as you recently stated in the Harper decision, that the North Carolina Constitution provides stronger protections for individuals as it relates to voting rights than the federal Constitution. So where there might be the absence of a claim under the federal Constitution, there may in fact be one present here. But the fact that the trial court cited, they did cite actually both cases.
Can you show me precisely where the trial court cited and relied in any way on the most recent decision?
Yes, Your Honor. In the paragraph 252, they cite to this very issue that we're talking about, the shifting of the burden, and they cite the Raymond decision there. And the Raymond decision supports what we believe was done correctly by the trial court in reliance on Abbott, which is it's plaintiff's burden of proof to put forth evidence. And while the history alone of prior finding of discriminatory intent cannot flip that burden, it can be relevant. And Abbott tells us that. Abbott says that the historical background is not irrelevant, it's a consideration. And Abbott also tells us that the prior legislation's intent can be considered by the trial court. And this is from 138 Supreme Court, the pen cites 2327. The intent of the prior legislature is not irrelevant. It can be considered to the extent it naturally gives rise to or tends to refute inferences regarding the intent of the later legislature. Then Judge Kavanaugh in the South Carolina case, which defendants cite to a number of times in their briefing, notes that under Arlington Heights, ongoing legislative action with the knowledge of disproportionate impact might be some evidence of discriminatory purpose, depending on the other facts and circumstances. And that is what we submit that the trial court did here. They considered different factors as it relates to the sequence of events, the legislative history, particularly the fact that during the legislative history, opponents of Senate Bill 824 put forth, they raised concerns and debate. They put forth evidence in the form of data. The prior no-match list performed by the State Board of Elections, the Curry report, which was the expert report in the House Bill 589 litigation, which showed that disparate ID possession. And then the Kimberly Strack presentation that noted the fact that the reasonable impediment provision that everyone in 2016 believed was a foolproof cure, in fact, was not one. And that showed, which the trial court found significant, that nearly 15% of individuals who utilized provisional ballot with a reasonable impediment provision were disenfranchised. And that's independent of the other around 1,200 or so that were not given a reasonable impediment provision, which our expert, Ariel White, found constituted a larger percentage of blacks than the electorate. So again, all that evidence can be considered by the trial court in the manner that Abbott tells us, and the Raymond Court acknowledges that too.
Counsel, is there any enabling legislation that this legislature could have enacted, given the purported previous racial motivation, that would have not been a violation of discriminatory intent, or would not have been produced by discriminatory intent?
Thank you, Your Honor. Yes, I mean, it's never been our position that it is impossible to pass a constitutional voter ID law in North Carolina. We readily acknowledge that there is a current constitutional amendment on the books that requires that a photographic ID be presented when voting, and that does allow for exceptions. So yes, that is something that the legislature can do. I wouldn't say there's no magic formula for how they go about doing that, but the way that the legislature can approach that task is by looking at the Arlington Heights factors. I mean, Arlington Heights does not provide safe harbors, it provides sort of guideposts. It talks about different circumstances surrounding the sequence of events. So where in our case, you had a scenario where the Republican supermajority tried to cram through this bill before they lost power on the day after it started the process, on the day after the decision in Covington, which set off alarms in their head that their supermajority was soon going to be over, and that they wanted to take this extraordinary opportunity to put something on the constitutional to the voters prior to an opportunity to actually vote for new representatives. I mean, those things have to be considered. So if you kind of remove some of the factors as it relates to each of the pieces of evidence that we've put forth in our case in chief, surely there's a scenario where the General Assembly can pass a constitutional law. And even the trial court even contemplates that, consistent with our theory of entrenchment, consistent with what defendants expert Professor Callanan even noted, that this is sort of rational behavior of a legislature trying to entrench itself by passing a more stringent law before they have the opportunity for a more watered down bill to be presented.
Well, what in the plain language of this statute, just the plain language, shows any sort of discriminatory intent?
In the plain language of Senate Bill 824? I mean, that's a difficult question, but Arlington Heights serves to provide a framework for challenging what is otherwise racially neutral laws, because that's sort of the day and age we live in now. There's not smoke and gun evidence of legislators standing on the floor saying, we want to discriminate against black voters, let's pass this law. That would certainly be a different case than this one.
Your argument will always be that because of the finding of discriminatory purpose of the prior legislature, that now there's discriminatory intent.
No, Your Honor, and that's not our argument here. House Bill 592 and that prior finding of discriminatory intent by the McCrory Court is part of the historical background in which we assess this current law under Senate Bill 824. Nowhere in the trial court opinion will you find the fact that because House Bill, that law was found discriminatory, therefore Senate Bill 824 is discriminatory, or because certain legislators voted for that law, therefore Senate Bill 824, the same intent carries forward. I mean, that is what the Abbott case is concerned about. That is what Raymond highlighted in the lower court decision in the federal case. An argument was put forth that because it's the same people pushing forth the same strategy, that therefore you can carry that intent forward unless there's some suggestion that they've done something to cure that. And that's not what's happening here. And again, you have to take a step back and consider it in the grand scheme of all the different subjects of inquiry under Arlington Heights.
Do you
So-
agree that the legislature did take steps to cure?
The trial court does not support that conclusion, Your Honor. The trial court shows that the only information before the legislature at the time that they were considering this bill, and we're speaking now strictly to legislative history, not the other subjects of inquiry, was the fact that there was likely going to be disparate impact against African Americans due to ID possession, and that the fail-safe that was touted in 2016 did not actually work the way that folks thought.
So what could the legislature have done to cure in this situation?
And again, you can go to different aspects of Arlington Heights. I mean, they could have taken the time to hear those concerns that, Representative Harrison, Senator Smith, Senator Van Dyne, all raised those concerns in legislative debate. And what happened there, and which, again, then Judge Kavanaugh noted was problematic, is there was no effort to address them. They just plowed ahead. They had that time frame that they had to act in to get their more stringent bill in place, and that's what they did. Again, you then have to consider the disparate impact evidence that we put forth, which shows that African Americans are more than 1.4 times likely to lack ID compared to white voters. I mean, that analysis in the future, future law, future litigation could be different. But you have to sort of look at all those factors together, and that's what the trial court did. None of them is dispositive. Nowhere does the court just short circuit its evidentiary findings by saying that because of House Bill 589, that's the end of this case. I mean, there's no suggestion that the legislature is not permitted to pass a new law at its first opportunity. But this law in particular, Senate Bill 824, because of the sequence of events, because of legislative history that showed essentially blind ignorance to race concerns, the fact that the disparate impact hits both on ID possession, and then the fact that the free ID is not going to be free, and the reasonable impediment provision is going to disparately impact African American voters. And then you get to the history, which North Carolina history which House Bill 589 and the Covington decision is part of that history, and it goes back decades. But what is relevant in this case is that pattern, and our expert, Professor Walutis, highlighted that pattern where you have racially polarized voting in North Carolina. African Americans tend to strongly vote in favor of Democrats, and there's that incentive for Republicans to discriminate against them for the political payoffs, and we saw that in McCrory, and we saw that through the evidence put forth by Professor Walutis and Dr. Anderson, that those circumstances haven't changed. The incentive remains, and it follows a pattern where African Americans have grown in terms of access to the ballot and political power, and then there's a backlash against that. So this, where the history comes into play, and this history, of course, can change with the passage of time or different circumstances on the other Arlington Heights factors, is in that last prong, the historical background. And we submitted that Senate Bill 824 was a continuation of that pattern.
Well, and again, that gets back to the question I asked earlier. If racial intent is always an argument, then how can the legislature ever pass a law that passes constitutional muster, in your opinion?
I mean, I think it is. No one of the factors is going to be dispositive, and that's not what happened here. The trial court didn't solely look at the historical evidence and then conclude racially discriminatory intent. I think that's what you're asking. So I think in North Carolina, given the history of North Carolina, given the way that African Americans reliably vote for Democrats and whites reliably vote for Republicans, I mean, in where we are in this case today, that incentive remains. That might not be the case in the future. And even if it is, that doesn't mean that the legislature can't overcome what might be a challenging aspect of that particular factor under Arlington Heights. And again, defendants readily admit the shameful discriminatory history of North Carolina. I mean, they take a different view of it as it comes to the last decade, but that's not in dispute here. I mean, that's going to be a part of these types of cases potentially going forward, perhaps not as much with the passage of time, but you then have to sort of look at the other prongs. You have to look at the sequence of events. So was it something that included a constitutional amendment that sought to hide the true bill terms from the voting people and then tried to ram it through while you had the supermajority? Or was it something where there was a more deliberative process where either the voters of North Carolina were permitted to actually consider which types of photo ID would be available, what form the law would take? And then similarly, if you go to the legislative history, is it one where there's sort of open debate, consideration of ideas, and when issues are brought up, some sort of joint resolution. And you see that like in the Virginia case.
How is this not a joint resolution with multiple Democrats voting with the Republicans?
The trial court credited the testimony of Senator McKissick, Senator Robinson, Senate Representative Harrison, that this was not a normal bipartisan process. Factually, the only two Democrats who voted for the veto override, there's only two of those, and one of them was then Senator Ford. And what we know from Senator Ford's testimony is that at the time that he was being touted as sort of this standard bearer of bipartisanship, he had lost his primary. He wasn't caucusing with the Democrats. He was campaigning for Republicans. And we learned through his cross-examination that the trial court considered had a misunderstanding about what the law actually permitted. And then the evidence also showed that the Republican staffers working with leadership failed to inform him of his misunderstanding. So he believed that free ID would be available on election day, every precinct across the state. That is not what this law allows.
And you would agree that if the trial court incorrectly shifted the burden of proof under Abbott, those findings of fact are not permitted to stand?
Yes, if the trial court committed a legal error like the burden shifting in Abbott, I agree with that statement. And if the trial court committed the legal error that the McCrory court considered, which is viewing the evidence put before the court in isolation, that could also be an error. So both Raymond and McCrory stand for the fact that the fact finding is, if supported by competent evidence, basically stand. In an Arlington type case where the fact determinations are sort of front and center of this inquiry, I think it almost compels a result here. But if there's legal error, Your Honor, of course, that is something this court could consider. But we would submit that did not occur here.
What evidence was presented that the experts for the plaintiff considered the amelioration provisions?
I'm sorry, Your Honor, you said what evidence was presented that the experts considered the ameliorative provisions?
That's right.
Okay.
The reasonable impediment provision.
Sure. So that sort of came up in two buckets of evidence. You have it on the legislative history, which I've talked about a little bit, which is the fact that during legislative debate, various senators and representatives brought forth the fact that the state board's own data showed that over 200,000 people were lacking ID. The prior iteration of this law showed that there was potential for disparate impact because of ID possession. And what we saw there was that there was no effort to sort of address that. They just plowed ahead. On the impact piece, which is sort of where the other area where this comes up, that is essentially what the testimony of Professor Kevin Quinn sought to inquire about. So Professor Quinn actually assessed, he was the only expert to do a full impact analysis of Senate Bill 824. And he made, using a sound methodology that no one has challenged, no one challenged his credentials, he made a determination that 1.4 times, that African Americans would lack ID 1.4 times more than whites. He found that nearly 7% a little bit over 7% of African Americans lacked the ID, which equates to over 100,000 voters. And he found that the various IDs that were added to speak to the increase in IDs that are in Senate Bill 824 as compared to House Bill 589, the various IDs that were added did not actually make a difference. We also saw the testimony from Ariel White, who spoke to the reasonable impediment provision. Again, the reasonable impediment provision was addressed during legislative debate. The information that the General Assembly had at the time was that some voters are going to fall through the cracks. And what Ariel White found was that the 1,200 or so voters who cast a provisional ballot without a reasonable impediment, their votes did not count. That population was more Black than the rest of the electorate. And her review of the reasonable impediment provisional file, which is something that was made available after the 2016 primary, showed that there were lots of, it told the story of errors being committed by election officials wherein individuals would not receive the reasonable impediment. And we saw that in the case with Daniel Smith and Paul Kearney, as plaintiffs told their story during trial.
So she looked at that. What bill was the reasonable impediment provision that you're referring to from 2016, what bill was that a part of?
House Bill 589.
Are you submitting to the court that the reasonable impediment exceptions were the same under Senate Bill 824 versus the House bill?
No, we would readily concede they are different.
So what evidence is there in this record that the reasonable impediment, the sweeping reasonable impediment provisions of 824 were properly considered by any expert? Because Dr. Quinn said clearly, I've not studied reasonable impediment exceptions under Senate Bill 824. So then that gets you to trying to compare apples and oranges with the 2016, what was applied by the Board of Elections versus what 824 actually provides. What testimony is there to say that what 824 actually provides would exclude any voter?
I think to answer that question, Your Honor, I think you have to take a step back and recognize that this is a circumstantial case. We are putting forth circumstantial evidence to prove what we believe is the case under the Arlington Heights framework. And Arlington Heights readily acknowledges that you have to do a sensitive inquiry of that evidence, and it's a holistic approach because you don't have smoking gun evidence. Would I agree with you that perhaps the better evidence would be rolling out Senate Bill 824 for an election cycle and seeing what happens there? Yeah, I'd probably give you that. But we put forth evidence that allowed the trial court to draw inferences about what might be the impacts going forward. And it's not disputed that the possession piece is in the record through the testimony of Kevin Quinn. I mean, you've heard reasons why it shouldn't have been credited. That's them just trying to reweigh the evidence. There is disparate possession in North Carolina based on the record here between African Americans and white voters. So that is all that is actually needed under McCrory, which says that you don't need overwhelming impact, you just need some impact. I mean,
But if there's no impact on the election because of the sweeping reasonable impediment exception, because every voter in North Carolina can vote either with the ID or under this sweeping exception, how is there any kind of impact?
Yes, Your Honor, the constitutional harm alleged here is not that any particular voter is not going to be able to vote. I mean, that is not the legal standard here. The harm here under an equal protection challenge is that voters are being treated differently, and that the fundamental right to vote for certain individuals is being burdened in a way that falls more disproportionately upon them. So our argument—
If nobody is prevented from voting, how does that show discrimination?
What the trial court credited in the record was the fact that the combination between disproportionate ID possession, the history of poverty stemming from North Carolina's history of discrimination against Black voters, which make them have negative consequences for political participation in the manner in which they can get IDs, in the manner in which they can travel, in the manner in which they can take off from work. That disparate ID possession, plus the fact that these ameliorative provisions, to the extent they allow someone to ultimately jump through all those hurdles and vote, great. But to the extent they're falling on a particular class that is less able to overcome them because of that history of discrimination and that lasting impact, which is poverty and its negative consequences on political participation, that is what our disparate impact showing was put forth and was credited by the trial court. And again, you have to— that is not the only piece of the evidence here. You also have to consider the sequence of events and the legislative history and the historical background. So we can sort of drill down into the disparate impact. We made our evidentiary showing there through the disparate impact and the possession rates, which McCrory says is all that's needed, because Arlington Heights also says, impact is not the sole touchstone of these claims. But then you have to look at the other aspects as we did and as the trial court credited.
Well, the trial court did go into a lot of detail in explaining why addressing the so-called reasonable impediment process deters voters and otherwise keeps people from even trying if they want to, and makes it more difficult. And it disproportionate way as to African-American voters, doesn't it?
Exactly, and that's what the legislature was made aware of during legislative debate. So they were aware of that fact, and there's nothing in the record suggesting that they then made a special effort to address what Kimberly Strack at the time was telling them.
Well, and if I'm reading this correctly, there was also expert testimony from Professor Hood that attempted to rebut some of that. And the trial court talked about it in some detail and said, no, that doesn't really apply here, and it doesn't blunt the effect of the other evidence that I've already heard and decided to believe.
Exactly, Your Honor. So what Professor Hood sought to do is compare the experience of a South Carolina reasonable impediment provision in a prior election to see what inferences could be drawn from that in North Carolina. I mean, the same type of inferences that were drawn by looking at 2016 and going forward to Senate Bill 24. And what the trial court found was that his testimony did a couple things. It sort of failed to consider anything about North Carolina specific. It standing in a vacuum was not a good comparison for what's going on in North Carolina, because in North Carolina you sort of had evidence of an ineffective reasonable impediment provision. And then in rebuttal, our expert professor Kevin Quinn actually showed that if you did the Hood analysis utilizing, considering both active and inactive voters, which in South Carolina and North Carolina, active and inactive voters are still eligible voters, it actually showed the disparate impact against African Americans, both on turnout, which is what he was assessing. So again, these are examples of what defendants have put forth in terms of responding to these findings. I mean, they're fact disputes masquerading as legal conclusions, because they are stuck with the fact that they've considered this evidence already. The trial court sat through the testimony of Kevin Quinn, through the testimony of Nate Hood, the testimony of Janet Thornton, and ultimately concluded that the evidence put forth by plaintiffs was more credible and was competent, and therefore that made those findings that allowed it to ultimately make the finding regarding discriminatory intent here.
Well, I haven't heard anything from anybody to indicate that the job of looking at the evidence and determining its weight and credibility isn't well within the authority of the trial court as he exercised it here, or they did. Do you see that anywhere?
No. I mean, I think that is, there is an impressive amount of evidence supporting the fact findings that we see in this majority opinion, as it relates both to our burden of proof and even then when the burden shifts to defendants in terms of.
Is there anything in any of the cases cited by your side or the other side that would indicate that the treatment of the evidence here isn't within the trial court's authority in analyzing the Arlington Heights factors?
No, Your Honor. And that's, I think, when you think about some of these comparisons to other states, so South Carolina ID has been brought up a number of times by defendants. The Lee case has been brought up by defendants. And even Raymond, a Fourth Circuit addressing this same law, it is always going to go back to the context of the particular case and considering the evidence put forth by the plaintiffs in trying to prove discriminatory intent. All those cases sort of look at the same types of things, and you can, when you start making those comparisons, you can see, Virginia's law, the substance is a little bit different, the process is very different. They were passing a law that was meant to meet preclearance. They were trying to reconcile with HAVA standards. Their legislative debate showed a very different record than the one that we see here, which strikes a lot of suspicion based on the fact that these concerns were ignored, that they just rushed ahead. That, again, this was the first time that the lame duck session was reconvened to pass implementing legislation flowing from a constitutional amendment. This is the first time that the manner in which they did that failed to put limitations on the way in which what topics could be addressed. And that's, again, testimony from our experts, Sabre Affairs. So, this is perfectly consistent with how you address these cases. They are totality of the circumstance cases. They're circumstantial evidence cases. And we would submit that they strongly support the findings that were put forth here, and that those findings compel the court's ultimate conclusion here. If no other questions, I ask this court to affirm the trial court's decision striking down Senate Bill 824.
Thank you, counsel.
Thank you, Your Honors. Just a few points. We would submit here that the key problem here is that the plaintiff's theory of the case is not supported by the evidence in this case. Their theory is partisan entrenchment. And so we've heard talk about a 1.4% difference in ID possession. First of all, that's dividing two percentages by one another, which the United States Supreme Court has said is improper. It's actually only about a 2% difference in ID possession rates. And we dispute that is even a valid measurement. The majority of the IDs were not even attempted to be mapped. But what is key here is whether people are going to be allowed to vote, because the only way a party can entrench itself is if its political opponents are not able to vote. And this legislation makes sure that everyone can vote. We've heard about potential implementation errors, but as the Fourth Circuit said in Raymond, implementation errors do not go to the intent of the General Assembly that was enacting that law. And the disparity in ID possession in the South Carolina case, there was the same alleged disparity in ID possession. It was 96% for whites versus 92 to 94% for African Americans, was the evidence before the court in that case. But the court said the sweeping reasonable impediment provision, which is not nearly as sweeping as the provision here, there are multiple ways in which the ones I listed in my opening, the reasonable impediment provision is more forgiving here. This is the most forgiving reasonable impediment provision in the nation. So the notion that this was meant to be passed for partisan entrenchment just does not match up with the evidence. The other key point, again, 5 Democrats voted for this law, 4 in its final form. Why would any Democrat vote for a law that was meant to entrench Republicans? They have some arguments about Joel Ford, but not about Senator Don Davis, not about Representatives Hall and Goodman, who voted for this bill in its final form. There is no explanation for why they would do that if it was meant to entrench Republicans. And there definitely was a flipping of the burden of proof here. In addition to what I said in my opening in paragraph 230, the Superior Court said this is not like a typical case where a General Assembly does not have to show that its law won't have a disparate impact because of that history of HB 589. So clearly flipping that burden of proof and making McCrory essentially was the linchpin of the decision. And so for all these reasons, we ask that this case be reversed or at a minimum be remanded for application of the proper standards. Thank you.
Counsel. Thank you, everyone. Mr. Clerk.
Rise. Oh yes, oh yes, oh yes. The Supreme Court of North Carolina will be in recess until 9:30 a.m. tomorrow morning. God save the state and this honorable court.